I have filed an additional affidavit in item number 14, Lordship. Regarding some assets and liability statement filed by the respondent, suppressing some facts.
Okay.
That is why yesterday I have filed after going through it. That may be, registry may be directed to bring.
Yes. May it please, your lordship. Item number 13, minute 13. I have sought the consent also. Could it be taken up next week, minute? It's a very unfortunate case where the person, wife is not turning up and he is not able to step out of the marriage. That's the only issue.
What's happened to the wife? Has she come?
No. We have tried everything. Only on the quantum. What is to be paid?
13.
9th.
13 is what do you mean quantum? 13 is with regard to a divorce decree. Your divorce decree was rejected. Even ex parte was ex parte.
Eventually, what earlier fell through on the earlier rounds when the hearing was there, that things were gone. So Mr. Goswami was there as the amicus to, if you're ready to pay, like what should be the structure of payment for the wife and the daughter. That was only the thing, as it fell through. Of course, the matter is not concluded yet. Only I want that. Man, we have different problems at back home, but this is a
Okay,
different kind of problem.
Huh? You've got matters. Then
10th, grateful book, obliged.
Your Lordship, listing of an IA in a criminal appeal, Your Lordship. Can it be next week, Your Lordship? Oblige, Your Lordship. Oblige.
So with the consent of the other side, I'd like to mention item number 15 for adjournment.
15.
Yes, that's
On the prayer for adjournment made on behalf of
G. Ghosh, legal aid counsel.
D. Ghosh, legal aid counsel, which is not objected by the other side. This is the matter. Well,
I feel for the appellant, the Lordship may have it on a hearing day in January
January.
6th or 8th. Lordship.
Okay.
Obliged.
May I please, Your Lordship? I beg to mention item number 7. In this case,
Seven. 7 is with all the rest.
Objection, madam.
He has not filed.
Yes.
7, 8, 9, and 10
Yes.
is connected.
They're
supposed to. Oh,
Yes.
sure.
that Pratik Majumdar.
They're supposed to file their affidavit.
we have filed the affidavit yesterday.
When
Yesterday.
have you served a copy?
No, in so moto, maybe.
No, but then Acha.
So motor.
Acha.
Neither of the Guwahati High Court lawyers have the position to publish.
You wait. No adjournment. Sorry. You don't want to come, you don't come. We know how to deal it.
May I please, Your Lordship? I have mentioned one case, Lordship, yesterday for listing today, but due to some defects, Lordship, it could not be listed
Then
today.
it was your fault.
Lordship, can it be tomorrow, Lordship?
Oh, the one that you wanted to withdraw again.
Tomorrow, Lordship.
Tomorrow.
Yes. And Lordship, one more matter.
Have you cleared the defect?
Yes, Lordship.
Okay.
One more prayer, Lordship. One more repetition I beg to mention for tomorrow, Lordship.
Why?
That is also surfacey. The bank will take possession tomorrow, Lordship.
That will take.
Yes.
Possession
We have
tomorrow?
received the notice only on 28th of
Is there? Okay, list it.
much obliged, Lordship.
May it please, Your Lordship. Your Lordship, I'd like to mention for listing, we filed on 17th of November, matter pertaining to Surface Act. Any date this week, sir. Any date this week, as per your convenience. Please.
Okay, Friday.
Much obliged.
May I please, Your Lordship? I beg to mention one criminal appeal for orders on 9th of this month, 9th of December.
What is the matter about?
Matter about POCSO related matter.
So what do you mean?
20 years punishment.
What order do you want?
Orders, my lord, regarding service, my lord.
That is service. Okay, nice.
Obliged.
May it please, Your Lordship. Lordship, I beg to make mention of item number 3.
3 yes.
Lordship, in this case, for the appellant, we have been newly
You have been newly engaged
Yes, your
from
lordship.
the appellant side.
Yes, your lordship. I've taken the consent of the other side. If your lordship may kindly fix this matter in the last week of January.
We were ready to do it today.
Lordship
It pertains
difficult.
to my.
Not. We have not filed addressing Wakalatnama also, like we will
Okay,
file in
right.
course of
On the prayer minutes.
and gets.
Learned counsel from the appellant.
Yes, your lordship.
Have you filed a vakalat?
We will be filing in the course of the day.
Who submit that she'll be filing vakalat on behalf of the during the course of the day. This is the matter on, who's for the other side?
I'm for respond number one.
Any objection?
No.
This is the matter in January. And,
Lordship of feasible first of.
and in as much as there is no objection from there.
28 problem. It came at 27. Problems.
Deeply obliged.
May it please your lordship. Lordship, I beg to mention for listing of a criminal appeal number 362 of 24. Lordship, the matter is for hearing and paper book is ready and copies have been served, lordship.
Why are you are for the appellant?
Yes, lordship.
It's under which section?
Lordship, it's a POXO matter.
POXO matter.
Yes.
6?
Lordship, can it be on 11th?
No, is it a section 6 matter?
Yes, lordship.
You have fixed a lot of. We fixed a lot of matters, that's the problem. Hearing matters we have fixed.
As
Why it's a, what is their ground?
Lordship, the age of the victim has not been proved.
Age of the victim. According to you, what is the age of the victim?
Lordship, she is, according to the medical examination, she is more than 17, less than 18 somewhere.
Then that still comes under POXO.
Lordship, it's I would say it's a gray area, Lordship, because medical examination, always there is a margin of 3 years.
It's, okay, there's no document to prove her age.
No, Lordship.
So it's basically on the basis of the ossification test.
Yes, Lordship.
The ossification test has been done.
Yes, Lordship.
So that minus 2 years, minus plus 1
Yes.
years have to be considered. That is your case.
Lordship, also there was no such injuries.
Theory is not required to prove that rape has been committed.
Yes, Lordship.
Only age being, okay. Put date. This one.
Deeply obliged.
My lord, in respect of out of 15, my lord, 4 have been already paid, and in respect of 11 appellant, my lord, the FS has been submitted to the government, my lord, financial sanction. So they will be paid very soon, my lord.
Kindly similar order 28 June 25. Last 208.
Huh?
28.
Time was.
My lord, it is in the final stage. The financial sanction has been submitted to the government, my lord.
Financial sanction has been given or is
Yes,
yet
my
to
lord.
be given?
Given, my lord.
Given.
Submitted to government, so it will say they will be.
Then
paid.
what remains, Mr. Counsel? It should be paid within a specified time limit, that's all. So you'll be paid at what rate? 900?
Yes, my lord.
Only 4 is paid, my lord. Only 4 appellant is paid, my lord.
So they are saying that the 11
Now
will be
11 is pending and another next item, my lord, 241. That was also pending.
441.
To 241.
Huh? How much? 241. 241. What about those 241?
In respect of the second item, my lord, the verification report from the concerned district officers have been sought for by the directorate, my lord. So that has not been received, my
My
lord.
lord, kept it pending, my lord, and that took time some.
Both the pending, my lord, otherwise. no problem. The first, so we can dispose of saying that financial. Second matter, we can keep it. I think first matter we can dispose of. Second matter, we'll keep it
Last
pending.
matter is in the final stage, my lord.
Because we'll give a specified time period within which to pay.
Yes,
My humble submission, the both the matter kept it pending and gave the specific
Yes,
time.
no, no.
My lord, this specific order 2013, my lord, they to pay, but that was not
On
paid.
merit, they don't have any.
No, my
appeal,
lord,
my
I
lord.
have no objection, but I have my only complaint kept it pending, my lord. Kept it pending, my lord. It took time, I have no objection, my lord. They took time. Only kept me pending. Kept it pending, my lord. Both are pending, my lord.
Yes, yes, I think, yes.
Second one is nothing else. We dispose it of nothing.
That's our first one. Okay, right. In this item 1. Heard, Mr.
HL, my lord.
A. Charlie Leonard Council for the petitioners. Also heard Mr. D.P. Bora for the health department.
Yes, my lord.
Who else is there? Mr. A. Chalia
For finance.
for the finance department. So you have approved
Yes, my lord.
payment.
The financial sanction has been given. Ceiling proposal will be moved as and when.
Oh, ceiling proposal. When are you moving the ceiling proposal? When?
My lord, it will be moved very soon.
When? You move it within a week. It will give a direction.
Yes, my lord.
Okay, right. The case of the appellants is that they have not been paid their monthly consolidated salary or area.
Honorarium, my lord.
And
Honorarium.
honorarium of rupees
900.
9,000, 900
900, my lord.
per month from their date of appointment until 30th September 2010.
Yes.
Correct? There are 15 of them out here. How many,
4 have been already paid.
I would say 11 left.
Yes, my lord.
Mr. D.P. Bora submits that that out of the 15 appellants, appellant numbers, who are the 4 appellants?
Appellant number, my lord.
The 4 appellants.
5, 9, 11. 5, my lord, appellant number 6, 7, 8 and 9.
6, 7, 8, 9
9.
have been paid their area area consolidated on honorarium at the rate of rupees 900 per month from their date of appointment until 30th September 2010. He submits that financial approval has been obtained from the finance department for payment of the areas of the remaining appellants. Full stop. He further submits that ceiling proposal would be submitted by the health department for payment of the areas of the remaining appellants. And as and when the said approval is given, payment will be made to the remaining appellants. Next, Mr. A. Taliha, appearing for the finance department. also submits that the financial approval for payment of the areas of the remaining 11 writ appellants has been given. And that payment can be made by the health department as and when they seek approval of the sealing proposal to be submitted by the health department. Full stop. Next part. The issue pertains to the judgment dated 23/7/2017 passed in WPC 900 of 2030, by which the state government was directed to pay to the petitioner their area consolidated honorarium from the date of their appointment. As it has been stated by the respondent that payments would be made to the writ appellants shortly. We are of the view that the present writ appeal can be disposed of. That is 297, huh? Accordingly, the director or who? Secretary?
Director of.
Director and secretary, both.
Yes, ma'am.
Where are the parties?
That is party that page 4, my lord, page 4.
Accordingly, the Commissioner Secretary to the Government of Assam, Health and Family Welfare Department, bracket A. Family Welfare, bracket A Department, and the Director Health Services, bracket Family Welfare, Assam, are directed to submit the sealing proposal for payment of the arrears of the writ appellants, remaining writ appellants, within a period of
10 days.
a period of 10 days from the date of receipt of a copy of this order. The Commissioner Secretary to the Government of Assam Finance Department shall accordingly pass necessary orders on the sealing proposal, to enable the Health Department to make of the areas to the remaining writ thereof. The entire process should be completed within a period of
1 month.
a period of 1 month from the date of receipt of a certified copy of the file. That is, the appeal is accordingly disposed of. So we won't start with another application.
So same, my lord, same.
No, how can we say about it? So it's slightly different.
No, my lord,
Report has to be
judgment is same, my lord.
Judgment same,
is
issue is
same.
same, but the
Same, ma'am.
status of this petition is different. The directorate has sought for the verification from the district concerned.
Okay, right.
district.
Miss, the matter pertains to the order dated, the same order, huh? Order dated 23/7/2017, passed in WPC 900 of 2013, wherein female health attendant to be paid their area honorarium from the date of their appointments. In this regard, Mr. D.P. Bora, learned counsel for the Health Department, submit that a report has been called from all the
concerned district authorities, my lord.
from
The director of health services,
by
FW,
by the Director of Health Services
within bracket FW,
within bracket Health
FW,
Family Welfare
family welfare,
to all the
concerned district authorities.
who are they?
My lord, that is additional chief medical and no. Additional chief medical and health officer, my lord, of all the districts.
The district heads.
Yes, my lord.
That is the additional
Chief medical and health officer
CMO, Chief Medical Health and Health Officer,
within bracket FW.
bracket FW. With regard to the 241
Yes, my lord.
appellant
Yes, my lord.
are claiming payment of that any aerial honorarium. When did you ask for the report?
My lord, it is quite some time, my lord. Yesterday I have asked them to issue a reminder, my lord. They have not received it, my lord. So probably today or tomorrow they will issue a reminder, my lord.
Post office submits that a reminder is being sent tomorrow to the district head for the report. The Mr. D.P. Bora shall obtain instructions, up-to-date instructions with regard to the same. List the matter on
Interfication, my lord.
sixth.
Yes.
My lord, can it be after Bihu vacation? Because I am pursuing, my lord, they will issue reminder by today or tomorrow.
Information has to be sought from various districts and some of them have expired, so next of kin certificate and account details, everything has to be.
You see, Mr., how long has this been, how long has the matter been pending?
Their lordship, these petitioners have come after entire batch has already received. So again, a re-verification has to be done, lordship. We had already carried out the.
Okay, right. 20th.
Obliged, my lord.
Lordship.
Yes.
May I please, your lordship? Lorships, as per the previous order, your lordship, by this honorable court, the affidavit was already filed, but the latest instruction has been received, your lordship. The revenue department has already released the fund to the deputy commissioner to carry out the process of the eviction of the encroached land, your lordship. Can you peruse the instructions, your lordship? Also, the second page, your lordship, may I have it? Second page, your lordship, the amount is already issued, your lordship. Budget allocation has been issued. Your lordship.
So under Nagaon district.
Yes, your lordship. So that DC can now carry out the eviction.
So what remains? What remains in this petition? End of the matter. Your job is done.
Direction will be given, my lord, then I have to close them.
They are doing it, then we will see. Right. Heard, Mr.
Ekhoni.
Learned counsel for the petitioner. And Miss
N border for 1 and 2.
S. Borderline.
N
Borderline. For number
1 and 2.
1 and 2. Mr.
I am for 3, 4 and 5.
3, 4 and 5. Huh? 4, 1, 3, 4. The petitioner has filed this public interest litigation to protect public land from large scale illegal encroachment. According to the petitioner, 76 families have illegally occupied 18 acres of government grazing reserve land. Out of 38 acres, constructing houses, shops and pond. The petitioner's case is that the acts committed by these encroachers have been confirmed. Official reports submitted by Lot Mandals and Circle Officer Samoguri Revenue Center. The inaction of the authority, despite repeated representations and official reports, is alleged to be arbitrary, unfair, and violative of Article 14 and 21 of the Constitution of it. The petitioner, next, the petitioner's counsel submits this para that though the petitioner had submitted a writ petition, that is WPC 241/2025 earlier, the same had been withdrawn with liberty to file a PIL on the same subject matter. Hence, this PIL seeks a writ of mandamus directing the authority to evict the enclosure based on the circle officer's report and to restore the land for public. Next part. The affidavit, additional affidavit filed by the additional district commissioner, Revenue Department, Nagaon. Revenue
Yes, Your Lordship, that
Department, Nagaon,
22nd September 2024.
filed on 22/9/25, is to the effect that as per the report of the circle officer Samaguri Revenue Circle, wide letter dated 8/9/23 and 23/2/24 regarding encroachment of government land at village Rupahi Bakat Gaon under Khatowal Moza. Process has been initiated for removal of the enclosure. Accordingly, CO Samaguri has submitted eviction plan and estimate wide letter dated 2/9/25 with an estimated value of rupees 2,34,500. The said eviction plan and estimate has been submitted to the additional chief secretary to the government of Assam, Revenue and DM Department, while letter dated 15/9/2025, seeking approval for grant of budget against the estimated amount to evict the enclosure. Next paragraph. Subsequent to the letter dated 15/9/2025, seeking budget estimates of rupees 2,34,500 to carry out eviction of the enclosure, the state government has communicated a budget allocation of rupees 135.95869 lakhs for the financial year 2025-26 for conducting eviction drive under the Nagaon district. Including the area covered in the present PIL. The next paragraph. The letter dated 2/11/2025 issued by the state government indicating the budget allocation of 135.95869 for the financial year 2025-2026 for conducting the affection drive. States as follows. Take it down. This one. Okay. Let's take it from here. This is issued by the
Additional. director.
additional director of land records Assam. This is follow. Next. In view of the above letter dated 2/11/2025. This court is of the view that the process for eviction would be started off in right earnest by the state respondent
By the deputy.
in
commissioner,
accordance with law.
By the district commissioner.
By whoever, by the competent authority in accordance with. The period is accordingly closed.
Lordship, me, that instruction was a part of the record.
Okay, the letter dated 2/11/2025 issued by the additional director of land records Assam is made a part of the record and marked as Annexure X.
Diplo.
Pleasure, Lordship.
May it please the lordships. My lord, the appellant before your lordships is one of the senior most deputy general manager rank officer of the general insurance company of the country. এখন কি লাস্টত দি দিম Lord, he is one of the senior most DGM rank officer, my lord. He has been superseded twice for promotion to the grade of general manager. Now, first supersession was in 2022-23, and the second supersession was in 23-24.
Superseded by junior.
By his juniors. My lord, incidentally, the criteria considered, not promoted. The aspect. Hello. Manoj.
I was asking him.
No, Manoj, I was only answering Manoj's question. I'm sorry.
No, he's saying no, he's saying junior, not junior. No, I'm just asking that only. Superseded by juniors or not?
No, Manoj, because scale 6 and scale 7, everybody's equal.
Okay,
There is no seniority, juniority there.
okay,
That's not correct, my lord. I have been superseded by my juniors.
okay.
Now, first, my lord, please come to, for the seniority part, if your lordship would kindly come to page 101.
101.
Yes.
Yes.
Now, if your lordship would kindly come to serial number 35, my lord,
Yes.
and let's see my zone of consideration serial 4. That means my seniority is at serial number 4.
ZOC.
Yes, zone of consideration 4.
Okay.
Yes. Now, my lord,
Where are the private respondents?
yes, the private respondents. Serial number,
You were the petitioner also.
yes, I was the petitioner.
66, 86, 87.
Page 101, my lord. Serial number
82, 86, 87.
first to
Also 86.
serial number 86, my lord,
Serial number 86.
at page 103.
87.
87,
Then 82.
82,
68.
68, Milord, whoever is in the zone of consideration below 4 are all my juniors. Now, my lord, please come to the promotion policy, the rules. First, lordship will kindly come to page 179. The policy is very clear, my lord. It lays down absolute objectivity, but in practice, what has been done is the other way around. Broad criteria for promotion. Lord, we are concerned with promotion from grade 6 to 7. 7.1. The organizational needs by way of promotion of officers from one scale to another shall be fulfilled in such manner that merit is appropriately recognized while seniority is duly respected to the extent consistent with efficiency of the organization. In my humble understanding, my lord, the criteria of promotion is not per se merit cum seniority. Merit and suitability with due regard to seniority. That's my humble understanding of the policy of promotion. It's not.
Your understanding is
It's merit and suitability with due regard to seniority.
merit and seniority
Suitability, my lord,
and suitability.
with due regard to seniority. As we read the promotion policy, my lord, it will be absolutely clear. Then, my lord, will kindly come to next page. Eligibility and zone of consideration 8.1.
Yes.
For empanelment for consideration of promotion to the cadre of scale 6 and 7, an officer should have completed minimum 2 full years of continuous service in the existing cadre, subject to provision of para 17. Basically, my lord, it lays down the qualifying service required in the feather cadre. It is 2 years. And I'll show, my lord, how the rules are amended as many as 4 times to bring in person below the zone of consideration into for consideration. I'll show that. Then, my lord, will kindly come to next page, page 181, clause 9. The heading is qualifying benchmark for consideration of promotion to various cadres. Please come to 9.1.1. It envisages, my lord, screening. All officers in the eligibility cadre in GIC, that is General Insurance Company, and GIPSA member companies, empanel as per para 8.1 for consideration of promotion shall be interviewed by a screening committee comprising of 4 or 5 outside experts in the field of, say, management, human resource, organizational behavior, public administration, economic, psychology. So, my lord, once the zone of consideration is determined, then they are to undergo a screening process, my lord, by a committee comprising of 4 or 5 experts. Then 9.1.2 envisages, my lord, how it will be assessed. Screening committee shall assess the officers under parameters of conceptual level, vision, depth and range of overview of the industry, economy, planning ability, decision-making ability, management traits, positive attitude, problem-solving ability, including conflict resolution, management, overall leadership ability, etc., and submit their assessment recommendation to the promotion committee. So this is how, my lord, the screening committee will undertake a process of assessment. Then, my lord, the next process is, lordships will find at page number 185, eventually how eventual selection will be made. Towards the bottom of the page, 13.0.1.3.
Selection. Promotion committee shall select officers equal to the number of vacancies determined as per provisions of para 13.0.1.1 for so-and-so promotion for
What
placement in,
is in situ promotion, what is it?
in situation, my lord, promotion for placement in scale 6 or 7, as the case may be. Now, this is important. Based on overall merit, suitability, growth potential, length of balance service, qualification service experience in functional areas, and seniority of the MPanel candidates as may be assessed from performance appraisal and other records. This is why, my lord, I made that submission that this is not a criteria which can be per se described as merit cum seniority, that here there is a requirement of assessing merit, suitability, and also giving due weightage to seniority. Then, my lord, will kindly come to the next page.
So what are you trying to say? You're trying to say this is
Where will seniority also have a role to play, apart from anything else. And I'll satisfy your lordships on merit, my lord. Undoubtedly, I'm above everyone who were considered. Plus, I'm also senior. Therefore, why I was denied the promotion? There cannot be subjectivity of an unlimited thing, my lord. There has to be objectivity, has to rule over subjectivity. Otherwise, my lord, this selection makes no sense. Now, 186, my lord. Promotion from cadre 5 to 6 and 6 to 7. Eligible officers, after being interviewed by the screening committee, as per para 9.1, shall appear for an interview by the promotion committee. The promotional committee shall, after taking into account the assessment recommendation of the screening committee, overall merit, suitability, growth potential, length of balance service, qualification, service experience in various functional areas, and seniority of the candidates as may be assessed from the performance appraisal record as well as the personal interview, prepare a list of officers selected for promotion. The list shall be so prepared as to maintain the inter-se seniority of the concerned officers in the existing cadre. Such selection of officers for promotion by committee shall be final. List shall be to the extent of the vacancies available for the year concerned. Now, my lord, this is the promotion policy. It's really very objective, my lord. There's absolutely no, one cannot have any grievance about the procedure prescribed. Now, my lord, I'll satisfy your lordships regarding my merit before I take lordships to other aspects. Now, if your lordships would kindly come to page number.
Just a minute, one thing, just a minute, just let me see. Well, 179. About 7 point. That's it. Promotion to previous success shall be paid at full price.
Serial number কুড়িটা আমাদের জুনিয়র আলফা নজর রয়েছে Kharbanda too.
Yes.
Yes. Milord will kindly come to page number 72 of the appeal memo, Milord. This is my pleadings in the writ petition, Milord.
72.
Page 70. I'll read three paragraphs, Milord, 17, 19, and 20. Now I'm dealing with the merit aspect, Milord.
Yes.
That the petitioner begs to state, para 17, that he has an extraordinary service record and always kept the respondent number 3's interest at the forefront during his service tenure. Petitioner humbly draws the attention of your lordship that petitioner's leaning towards profitability as a main cornerstone is evident from the performance and results over the last 5 years from 2019 to 23, which is also the performance period considered by the management for his promotion exercise of 24-25. Then para 19, that the petitioner begs to state that he has had the opportunity to work across different continents and specifically on multiple projects which have not only allowed petitioner to demonstrate his dedication to the team's success, but also showcase his ability to achieve the corporate objective of growth with profitability. The petitioner has always strived to work and achieved his company's vision and mission to grow and generate profit. Para 20, Milord, that the petitioner begs to state that he was considered fit and suitable to oversee foreign operations of respondent number 3 on 2 occasions for the period 2008 to 12 and 19 to 23. It may be pointed out that selection procedure is a comprehensive feedback of all concerned departments at the head office of respondent number 3, which encompasses the analysis of major commercial risk, settlement of claim, reinsurance, investment, handling with foreign regulators, investors, and bankers. However, it is an irony that while petitioner is suitable for foreign assignment, but on his return with the impeccable performance result, his efficiency degree is lowered as not suitable and unfit for a domestic promotion exercise. So this is my perspective, Milord. Now, will Lordship will kindly come to their page number 119. This is also, Milord, part of the writ petition. Now, these are my, Milord, APR reportings, Milord, for the relevant period. The period in concern was April to August, Milord. Comment on performance of the appraisee and give an appropriate rating. Excellent performance on all front and on track of achieving targets given. Comment on major contribution made by the appraisee during consistently maintained profitability at branch with a possessed and professional approach. State briefly the efforts made by the appraisee towards institutional building. Company's image and standing is maintained in a small and competitive market. Comment on the general state of his health of the appraisee sound. Then my lord will kindly come to page number 121. In the light of your C, a comment on so and so, is the officer fit for promotion? Yes, he should be promoted and is well deserving. This is the reporting officer. Then at page 123, my lord, recommendation regarding suitability, suitable for any sphere. Then my lord will kindly come to page 129. This is for April 22 to March 23. Please come to B, my lord. If answer to O above is yes, do you think yes, he can take higher responsibility? Then my lord will kindly come to 132. This is the reviewing officer's part, my lord. Do you agree or disagree with the comment of the reporting? Agree. Fit, yes. Recommendation regarding suitability, yes. Then my lord will kindly come to page 141. This is for 21 to 22, my lord. Excellent performance on all fronts, on track of achieving targets given. Branch has generated profit in different circumstances. Maintain good relation and brand image in foreign territory, good. Then, my lord, at page number 145, this is the reviewing officer's thing. Good executive, hardworking, always try to expand his knowledge, etc., etc. Then, my lord will kindly come to page number 152. Sorry, 154, my lord. This was for 20 to 21. Agree with the RO. So this is how, my lord, he has maintained his merit all throughout consistently. Now, my lord, they have filed an affidavit in opposition, my lord. In the opposite, please come to page number 219, my lord. That is their understanding of the policy of the promotion policy. Please come to page 219. This was the, my lord, affidavit in opposition which they filed before the learned single judge. Please come to para 23, my lord. It is submitted that the seniority alone does not guarantee promotion to the top management cadre of scale 7 in company, as promotion to this cadre are based on sole criteria of merit as stipulated under clause 7.2 of the promotion policy. The factor of seniority has a limited role in empanelment of a candidate in the zone of consideration as per clause 8.1 of the policy promotion policy. But once empaneled in the zone of consideration, it is relative merit alone that determines the qualifying of a candidate for inclusion in the promotion list. But in my humble understanding, Lord, my submission, this para 23 is not absolutely correct in the sense, my lord, it does not jail with the promotion policy. Here, my lord, they would like to say it is merit alone which matters. That is their stand. Our stand is yes, merit has a role. At the same time, suitability and seniority are other aspects which cannot be given a go by. Then, my lord, most importantly, page 231. Now, this is there, my lord. That's why perhaps in para 23, why they say so. Please come to page 231. Last 5 sentences of para 40. At page 231. it is submitted. Has the lordships got it, Milord?
Yes.
It is submitted that promotion at such higher level are subjective in nature, given the profile and accomplishment of the candidate, coupled with the requirement of company for promotion post, which are open to be filled. How can it be subjective, Milord? So that's why perhaps, Milord, the language they have employed in para 23, this is the reason. So according to them, end of the day, it is the subjective satisfaction of the disciplinary DPC, Milord, that matters. So my humble submission is, Milord, that cannot be correct. Now, Milord, here in this case, okay, before there are 2-3 other pleadings, let me place that, then I'll articulate my argument, Milord. Milord, we filed an additional affidavit. Now, if your lordship would kindly come to the pleadings number 2, Milord, which starts at page 509. Additional affidavit which we have filed in writ appeal, Milord, to which they have replied also. Reply also, no?
No. This is it appeal. Oh, the file. Just. Yes.
Yes.
No.
Now, we have brought out certain factual aspects regarding, Milord, respondent number 12 and respondent number 9. Please come to para 4, Milord, at page 511. এইটো আমি কি মানে বিশেষণত আমি চাইছিলো আমি ক'ত পালো বস্তুটো কাম কেতিয়া দেখাইছিল Milord will kindly come to page 511. Yes, para 4, Milord. That the appellant respectfully states that upon a careful perusal of the official internal records of the company, the deponent discovered official statement reflecting operating surplus deficit record for the preceding 3 years. It is pertinent and material to note that as per the promotion policy, an aspect not disputed by the respondent, but rather admitted by the respondent as well, the assessment of candidate for promotion to scale 7 was based on their performance over the say 3-year period, which has been taken into consideration while determining the candidates who have been promoted pursuant to the impugned promotional exercise. A scrutiny of the such record found on the official archives of the company's internal data would reveal that respondent number 12, namely Lalit Kumar Kharbanda, who has been promoted to scale 7, has during the 3 years in question persistently recorded underwriting losses, therefore reflecting a sustained pattern of underperformance. Per contra and in stark contrast, the records would reveal that appellant's performance during the same 3-year period has been exceptionally good, making consistent underwriting net profit and surplus for the company, thereby evidencing commendable performance and the appellant's positive contribution to the company. As such, there exists a clear and objective difference in the performance of both the candidates, which ought to have been the primary and decisive basis for promotion and selection process. Now, page 514. Now, please come to page 514, Milord. Kindly see the performance of the appellant and respondent number 12. We have brought out in the form of a chart. Comparison of 3-year underwriting profit, loss and investment income between petitioner and selected officer at serial number 4 of the promotion list. Now, my lord, as far as appellant is concerned, he made a profit of 85.22 crore. And the respondent number 12, Lalit Kumar Kharbanda, he incurred a loss of minus 376 crore. Yet he has been preferred over me. That's why they say, my lord, it is subjective. And my lord, this affidavit, nobody has disputed till then. No? Huh? There is no reply. So please come to para 5, my lord. That the appellant further states, when the matter was heard before the learned single judge, respondents failed to produce or share the relevant record pertaining to the selection and promotion process before the appellant or his counsel, despite the fact that such records were admittedly relied upon during the proceedings. The deliberate withholding of such material documents, which form the very basis of the impugned promotional exercise, from the appellant constitutes a grave and serious procedural irregularity and reflects lack of transparency in the decision-making process. Then, my lord, paragraph 6 is regarding respondent number 9, my lord, against whom there was an FIR. Para 6. That the appellant further respectfully states that one of the selected candidate, that is respondent number 9, namely so-and-so, had a pending criminal case against her, and as on the date of interview and selection by way of promotion arising out of FIR dated so-and-so, registered under section 420(34) of IPC. It is submitted that the said fact was within the knowledge of the respondent authorities, and yet no action was taken to exclude the said respondent from of zone of consideration. Now, my lord, will kindly now, my lord, please come to the affidavit which starts from page 550 to 844, my lord, where an additional affidavit was filed by the respondent number 3 before the learned single judge. And I'll have your lordship's kind attention to page 698. My lord, the affidavit starts at page 550. It's an affidavit in opposition filed before the learned single judge by respondent number 3. In the writ appeal, sorry, I'm sorry. In the writ appeal.
Which page?
698. It starts at page 550. It's part, no, I can't hear you. It's part of the additional affidavit filed by respondent number 3 before the learned single judge. ठीक है? No. ठीक है. Page 698, Miller. This is their pleaded case. That it is respectfully submitted that paragraph 13.1.1 of the promotion policy indicates the guiding parameters for promotion committee for selection of candidate for promotion. The promotion committee conducts an objective assessment based on these parameters in making the final determination. Notably, the promotion committee takes into consideration performance appraisal record of the candidate from preceding 6 years as a part of the promotion evaluation. Candidates are allotted marks under the following parameters. They themselves profess, my lord, work record, that is ACR, then external assessment, seniority and interview. Kindly see, my lord. Here also they say it is seniority and interview. And what would be the, my lord, work record? They have defined in para 5, performance, major contribution, institution building, health, integrity, generalist, outstanding work, fitness. Now, my lord, will kindly come to the reply filed by the appellant in to that affidavit in opposition. May I have your lordship's kind attention to, my lord, page number 855. No, sorry, my lord, 847. My lord, while placing the promotion policy clause 8.1, my lord, where lordships had seen that qualifying service required is 2 years in the feeder cadre. Now kindly see how it was tweaked to just to bring in people. Para 10. At page 847. That as far as the above issue of including ineligible officers into the zone of consideration and other related issues are concerned, it is submitted that respondents, in order to illegally grant promotion to certain ineligible officers, change Rule 8.1 of the policy three times into financial years to grant promotion to below noted persons. My lord, these are the persons who has been benefited of this tweaking of this policy. And appellant is at last, my lord.
Para 10.
Page 848, my lord. Para 10, in the box at page 848. Now, because of tweaking of the, my lord, the policy, or rather reducing the qualifying service, my lord, all these persons, Rajiv Gupta, Vinita Joshi, Amardeep Grover, Shiv Shankar, Mini George, they stood, my lord, benefited. Now, please come to para 11. That in order to deny promotion to the appellant and grant promotion to junior ineligible officer, respondents departed from Rule 8.1 to make temporary exception to this said rule, lowering the eligibility bar. Now, first time it was done for empanelment for consideration of promotion to the cadre of scale 6 and 7, and officers should have completed minimum 2 years of continuous service in existing cadre and should have minimum 2 full years of balance service remaining. To overcome this difficulty, in order to include ineligible officers in the zone of consideration, rules were amended for the year 23-24 under Rule 22, stating as follows. Notwithstanding anything contained in the policy for the promotion exercise 23-24 for empanelment for consideration of promotion to cadre of scale 7, and officers should have completed a minimum of 1.5 full years of, so 2 years was brought down to 1.5. Then, my lord, will kindly see next para 13. Notwithstanding anything contained in the policy for the promotion exercise for empanelment for consideration of promotion to the cadre of scale 7, and officers should have completed minimum 1 full year of service. 2 years was brought down to 1.5, now it is 1. Then, my lord, further at para 14.
No, 1.5.
1.5. Then it is 1 year at para 13. Para 13, my lord. Minimum 1 full year.
Again, 16
seconds. Then, my lord, will kindly come to para 14 for 25-26, what they are doing. Notwithstanding anything contained in the policy for promotion exercise 25-26 for empanelment for consideration of promotion to the cadre of scale 7, and officers should have completed a minimum of 1 3/4 full year of continuous service in so and so, so and so. Now, my lord, this is how, my lord, they are tweaking the rules, my lord. Now, please come to 855, my lord. Now, this is very important, my lord, para 29.
Yes.
That further the promotion and interview committee have promoted officers who failed in key performance area targets and caused operation losses, while now neglecting the high target achievement and profit-oriented performance of appellant. Yet paradoxically, the respondents state that merit is the sole criteria of promotion. Additionally, in practice, only marketing vertical has the objective criteria of performance assessment among all portfolios. Respondent number 12, despite having failed across all assessment years in key performance area target, and even more so having reported consistent loss for all assessment years, was inexplicably promoted even when deemed to be below grade the data below bears out this. Kindly see, my lord. As I have already pointed out this. So he made the company to lose 376 crore. I made a profit of 85 crore. I was ignored and he was preferred. And he was, my lord, zone of consideration 6. Above selection stands expressly contrary to the claim of merit, while information with regard to key performance area, performance of other is also circumspect unless fairly and transparently disclosed or communicated to the Honorable High Court. It may be stated that respondents allocated marks despite negative no contribution, non-integrity, non-institution building losses, etc., validating the arbitrariness of the selection process. Now, my lord, most importantly, my lord, this is how the merit is to be assessed. But in their affidavit, my lord, they have not brought out this. It's very important, my lord.
They have only given the attribute.
They have given the attribute, but they have not given the details. And my lord, before the learned single judge, what was produced was, my lord, something like a comparative statement. Where are the contemporaneous records of the interview board members? Who has assessed whom how? None of these records were produced. Now, kindly see, my lord, performance 6. 6 for very good, 4 for good, 2 for average, so and so. This is how, my lord. Major contribution, how it is to be assessed, everything. And no reply has been filed to this affidavit. Then eventually, my lord, will kindly come to page number 862. Para 44. Page number 862, Miller, para 44. That with regard to the statements made in paragraph 14 of the affidavit in opposition filed by respondent number 3, the answering deponent respectfully submits that Rule 7.2 does not exclude seniority, but instead provides for allocation of non-arbitrary marks for seniority as already recorded in the impugn order and reproduced in the table matrix below. However, respondents excluded the significance assigned to seniority of a candidate who is to be allotted marks based on such seniority and in the process jeopardize the case of the appellant. Now, my lord, this is how they are to, my lord, make the assessment. Work record 60, seniority 10, screening 10, interview 20, total 100. And as far as, my lord, the work record 60 is concerned, my lord, this is to be as per this matrix. Now, records must reveal, my lord, how this criteria was applied to each and every person who was in the zone of consideration. Furnishing of a sheet which contains the total marks secured, that is no record. Where are the contemporaneous records? Supposing, my lord, there are 10 interview board members. Individual members must have assessed it. And very interestingly, my lord, 47 persons were in the zone of consideration, and the interview of the 47 persons were completed in less than 5 hours. You can very well imagine what was the exercise. Then page 863, my lord. It is pertinent to mention herein that above policy has already been referred to by the learned single judge, responding to the argument of respondents that all those selected, including appellants, were awarded equal marks in work record 60 and seniority. Well, how can respondent number 12 I get same marks? I'm not even questioning others for the moment, my lord. How can the appellant and respondent number 12 secure 60 marks, my lord? Unless some favoritism was done in this case. That's why they say, my lord, promotion at the level of 7 is subjective. This is the pleaded case.
Might have been a mistake.
Lordship is there to correct that mistake.
No, I'll clarify this. It was later clarified.
Yes.
Upon a query of the court.
Now, my lord, These are the facts. I'm a person, my attributes are well documented. These are all before the authority. Now there is a clear-cut promotion policy which envisages what is the qualifying service, then who will come within the zone of consideration. There will be a screening committee consisting of 4 to 5 outside experts of different field. Eventually, my lord, compiling everything, the promotion will be effected by taking note of merit, suitability, and seniority. Now, my lord, what I find from the pleadings of the respondent company, my lord, they would like to say that it is essentially a criteria which can be described as merit cum seniority. My lord, there is a difference between merit cum seniority and merit and suitability with due regard to seniority. My lord, we all understand what is seniority cum merit. Unless there is something, my lord, negative, my lord, the person who is normally senior will still a march over his junior. In merit cum seniority, we know, my lord, it is the merit which plays a more dominant role, and it is only when the merit is equal, the seniority may have a role. But in the third category, which in my humble submission, the present case category case falls, my lord.
Your case is that this is a hybrid mode.
Hybrid. Absolutely. It's a hybrid mode. Merit and suitability with due regard to seniority. Now, Lord, I'll place 2-3 judgments of our one judgment of our High Court, my lord, and 2 judgments of the Supreme Court on this point. My lord, now, as far as the factual aspects are concerned, it is very clear, my lord. They will have to satisfy your lordships by producing the contemporaneous records, how the interview board assessed the 47 candidates in the zone of consideration, having regard to the criteria of promotion laid down in the my lord promotion policy. Before the learned single judge, my lord, that contemporaneous records were not produced. The book list on this, ভুল করলাম CP কালরাটো আছে নেকি 94 supplementary 1 SSC 454 ভুল করেছেন এখন দিয়ে দিব লাগে আৰু 2016 2 GLT, huh? 2016 2 GLT 819. মই GLT খন দেখা মানে আপনি এই 94 খন আনক 94 supplementary 1 SSC 454 454 দুখন কিতাপ আছে নাই এখনকে দিয়ে দিও কিন্তু দিলা CP camera to hold it. My lord, 1994 supplementary 1 SCC 454. So can I?
Okay. Where is the statement between? Was it before the? It's not.
Huh?
It's- Was it before the Lalit Singh test? Was this projected before the Lalit Singh?
No, it was not there. Not there. This particular aspect was not before. My lord, after the
And
records
one thing,
were,
the assessment made by the, with regard to your performance in your work
yes,
is based on the APRs.
yes,
And anything adverse in the APR?
nothing. I've already.
No, not yours,
Huh.
the other person.
Yes, there are, my lord. There are.
Was it?
And my performance was much better
No.
because I was the only person who was selected for foreign assignment.
No, I got it. But was there anything brought on record or here that is?
No,
it
that
is
that my no, nothing was brought on record that my performance was.
No. With regard to respondent number 12,
Yes.
that in his APRs, there were adverse remarks. There were negative entries.
No, my lord.
These have not
No.
been.
It was not brought before the learned single judge, but these materials were before the authority, my lord.
No, that's what I'm
Ah.
asking. Is there any indication anywhere
Huh.
that these were materials before the authorities?
It is not there, but my lord, it has to be presumed that it was there since it's the part of the record.
Because
No. That was only, na? No, my lord, to be fair to the learned single judge, my lord,
these were.
this aspect was not brought out. That's correct.
You'll get your chance.
We will not pass any order without hearing you, Mr. Constable.
My lord will kindly come to paragraph 3 of the judgment, my lord. CP Kalra. Yeah, copy of the briefly stated, the promotion policy is that promotion to the post of station superintendent shall be on the basis of merit cum seniority, merit to be determined on the basis of assessment found in the assessment report, as well as performance at the interview. The minimum marks required for being empaneled is 70%. If a candidate gets less than 70%, he is not considered suitable for promotion to the next higher post. From amongst the candidates who have secured 70% and above, a list has to be prepared in order of their inter-C seniority, regardless of the marks secured and promotion given according to their placement in the panel. In our case, it is 60 million. Thus, after the merit of each candidate is determined and those found meritorious are identified, seniority plays a role at this stage of empanelment. This is the thrust of the promotion policy introduced in 1988 with a view to strengthening the managerial cadre. The appellant appeared in the interview in 1989 and it appears that he secured a total of 65.67 marks. That is, he fell short of the minimum requirement of 70% of marks for being entered in the list of candidates suitable for promotion to the next higher post. Having regard to the fact that he secured less than 70, my lord, the matter was not interfered. But nevertheless, my lord, the principles of law was laid down in this case, which your lordships will get at paragraph 6. Now, if your lordships will kindly come to page number 458, my lord will kindly come to placitum A.
No, out here, where does it say that 60% is the?
Yes, my lord, I have already shown, my lord, from that page. No, the exit. 1 second, my lord. At page 862, my lord.
862?
862, my lord. Wait, 862.
From where do you get this?
This is what was followed, my lord. There is no dispute on this.
Cut off.
Yes. Work record 60, seniority 10, screening 10, interview 20.
No, so where do you say, how do you say that 60 is the benchmark?
No, there's no dispute on that, Miller. There is no dispute on that. All secured 60. That's why we were considered. 47. Those were promoted.
Screening committee passed the person.
Only those who secured 60, my lord, there is a requirement of passing by the screening committee.
Where does it say that? Is it there in black and white written somewhere?
Yeah, 13.1.1.
Yes, my lord, it is a policy is there.
Let us see that.
1 second, I am placing them. My lord, the lordships will get that at, I think, page number 181. I'm sorry. 4-5 expert group কথা তো কোথাছিল?
9.9.1, 9.1.1, that is the expert.
Page number 181.
Screening committee.
That is screening committee. But that cutoff,
There's no cutoff mark.
you have to submit recommendation to all.
All officers in the eligibility criteria in GIS.
Cadre.
Miller.
In the eligibility cadre.
Cadre, yes. Cadre in GIC and GIPSA member companies, empanel as per para 8.1, that means one who has qualifying service of 2 years, for consideration for promotion shall be interviewed by screening committee. Then how, my lord, screening will be done? That is at 9.1.2.
There is no benchmark out here.
No, my lord,
For those who are
they have worked it out. From the records, it will be evident. 60. There is no dispute on that count.
Pleadings. Pleading.
There-
Pleadings
there
are
was
also.
nothing in the pleadings before the single judge
60%.
regarding this.
No,
This is a new issue that
no,
has been brought.
not a new issue, my lord. That is how everybody proceeded. There is no dispute on that count.
Is there any pleadings? effect?
No, it is not there. My lord, records will be evident. From the records, it will be evident. When they produce the selection record, lordships will get to know from this. Then, my lord, I was placing that CP Kalra's case, my lord. Then please come to page 458, Placitum A. I was referring to the judgment, you know. The promotion policy clearly envisages that merit shall be the primary consideration for promotion to the next higher post. Once candidates falling within the zone are tested for the purpose of determining their merit on the basis of their performance emanating from the appraisal report, as well as their performance at the interview, total number of marks secured, if not less than 70, would entitle the candidate to be placed in the group of meritorious candidates suitable for promotion to the next higher post. Once this group of meritorious candidate is determined, their arrangement in the select list has to be on the basis of inter-se merit. This method of assessing the merit of the candidate cannot be said to be in any manner arbitrary and or which has no relevance to the object sought to be achieved. The basic idea under the promotion policy is that the managerial post should be manned by candidates of merit, and once meritorious candidates are identified, seniority would assume the relevance of their limited purpose of their placement in the panel. It is true that on the basis of appraisal report and the grading given to each candidate, marks are assigned out of 60 marks. Out of the remaining 40 marks, marks are assigned to each candidates on the basis of performance at the interview. If candidate secures 70 and above, he is taken to be meritorious enough for the promotion to the next higher post.
Final. Consider merit is determined, same as Kalra, they will be promoted. There is a, here we don't find.
My lord, though the criteria laid down in CP Kalra is not exactly same as the present one, my lord, but my lord, this is one such criteria which is different from what was considered in Sivaya and all these cases where merit cum seniority proposition was laid down. Now, my lord, following CP Kalra, our High Court has delivered a judgment. Lordship knows under the PWD there is a similar provision, Roman Kolita and all these cases. There, my lord, 70% for merit and 30% for seniority. So our High Court has relied, that is, my lord, 2016 2 GLT 819. 2016 2 GLT 819.
Here again, you should have 21 marks. Then you will be inside group A, it will be senior cases. In this case, in the same, in this case, also, yes. Pointing of partition. Mostly from basic to addition, there shall be category 1 15, category 2 11. If you get 50, you are in the system, you will be placed in category 1. And inside category 1, if there are 5 people, they will be arranged in the seat. And first category 1 will be exhausted if they are staying between the available. Then your seniority position now, the next higher position will be nothing. Here I think because here also the promotion is by estimate.
Yes.
If your lordship would kindly come to para 21 and 22 of Ajay Bodley's case, my lord.
Yeah.
At page number 7 of that judgment, my lord. 819, page 2 ki mane?
Yes.
Para 21 and 22. We have given our anxious consideration on the issue in hand. The criteria for promotion above the level of superintending engineer to the cadre of secretary is undoubtedly merit cum seniority as envisaged under Rule 13.4 of the rules. Apt to say that in Sivaya as well as Shankar Day, the said principle of merit cum seniority has been interpreted to mean greater emphasis being laid on merit and ability with seniority playing a less significant role. Notwithstanding the fact that the said two case laws were not taken into account in Manikanto Das, the issue is whether recourse can be had to seniority while applying the carry of merit cum seniority. In no uncertain terms, Sibaya and Shankaracharya has propounded that seniority can only be weighted when merit and ability are approximately equal. This is the test where seniority can be allowed to bear significance or have legal sanctity. Milord, in Sibaya and Acharya's case, regarding role of seniority, it was said, Milord, it is only when merit is equal, it can be. But the exception to that is para 22. When and how can a situation arise when merit among eligible officers can be adjusted to be at par with each other or approximately equal? Answer can be reached in C.P. Kalra's case, which finds consideration in Raman Chandra Kolita, the source of the notification dated 24/2003. In C.P. Kalra, Apex Code was seized with a promotion policy which envisages the primacy of merit for consideration for promotion to the next higher post on the basis of merit cum seniority. Apex Code held that once candidates falling within the zone are tested for the purpose of determining their merit on the basis of their performance emanating from the appraisal reports coupled with their performance at the interview, the total number of marks secured, benchmark fixed not less 70, would entitle the candidate to be placed in the group of meritorious candidates suitable promotion to the next higher post. Further, once this group of meritorious candidates is determined, their arrangement in the seniority list had to be on the touchstone of the inter-SC seniority. The apex court held that this method of assessing merit of the candidate cannot be construed in any manner arbitrary or one which has no relevance to the object to be achieved. Having noticed the dicta in CP Kalra, the purport of the notification, which should now require elucidation, merit in the final categorization follows a ritual where 75% points is earmarked on the basis of grading in the ACRs of the previous 5 years and remaining 20% for seniority, that is on the basis of the completed year of service. Whereas in the segment of merit, the maximum point is fixed at 20 in the segment for each completed year of service up to 30 years and above. An officer reaching the cutoff mark, that is 21.16 and above, is categorized as Class A and would fall in the same group of meritorious candidates, merit being at par or approximately equal on securing the so and so, so and so. Now, my lord, if we apply CP Kalra or my lord Ajay Bodloy, since we have all secured 60, then I should steal a marks by virtue of my seniority. And my lord, Lordship has posed a question that it was not before the learned single judge. For a moment, if your Lordship will kindly take the trouble of coming back to page number 862 for a moment, my lord. Why we brought out this? Because of their stand before the court, my lord, learned single judge. Now, if your Lordship would kindly come to 862. Now, from that box, my lord, what appears is workload 60, seniority 10, screening 10, interview, so and so. Now, different metrics are given. Then please come to page 863, my lord. It is pertinent to mention herein that above policy has already been referred to by the learned single judge, responding to the argument of the respondent that all those selected, including appellant, were awarded equal marks in workload 60 and seniority if belonging to the same batch. So this was their case before the learned single judge.
What do you, Mr. Chaudhary, what do you wish to, means what is being emphasized here by you now?
What is being emphasized? No, Lordship has posed a question that is the 60 is the cutoff thing or something. It was not before the learned single judge. It is in that context I wanted to point out that. Yes. So, my lord, now the matter is very simple. By their own saying, my lord, that we all got 60.
No, but you will have to show us one thing also, that what is the manner for preparation of this select list?
It is given
In
13.1.1
Kalra and that one, there is a method.
method.
Now, what is the method here?
Yes, yes, I'm mobilized, my lord. No, yes, yes. My lord will kindly come to 181, my lord. Please come to 181. Sorry, my lord.
186.
185
13.
and 6.
Is this in situ promotion? No, it's a regular promotion.
Now, page 186, my lord. Eligible officers.
Page?
Page 186, 13.1.1.
Yes.
Eligible officers after being interviewed by the screening committee, as per para 9.1, shall appear for an interview by the promotion committee. The promotion committee shall, after taking into account the assessment recommendation of the screening committee, overall merit, suitability, growth potential, length of balance service, qualification, service experience in various functional areas, and seniority of the candidate as may be assessed from the performance appraisal record as well as personal interview, prepare a list of officers selected for promotion. Same has been reflected in the judgment. And seniority.
Next slide.
Yes. The list shall be so prepared as to maintain inter-SC seniority of the concerned officers in the existing cadre. Such section of officers for promotion by committee shall be final. The list shall be to the extent of the vacancies available for the year concerned. Well, this line is also very important. list shall be so prepared as to maintain the interstate seniority of the concerned officer. Yes, yes, yes.
And have assessed the PAR as a personal interview. The report police.
Now, my lord, this sentence, perhaps lordship wants me to respond to this. The least so prepared as to maintain the interstate seniority in the existing cadre. That means, my lord, eventually, once you are in that 60% or 70%, whatever it is, the seniority in the feather cadre will determine the position in the selected
Can you
list.
come to page 187.2?
My lord,
Page 179.
yes. Organizational needs by a promotion of officers from one scale to another shall be fulfilled in such a manner that merit is appropriately recognized while seniority is duly respected to the extent consistent with the efficiency of the organization. Yes.
Up to 7.2.
While promotion to scale 6 and 7 shall be based on sole criteria of merit, promotion up to shall be based on overall rank obtained under the various parameters for measuring the merit and seniority among those. If this is how, lordships cannot read 7.2 in isolation. It has to be read as a whole.
So can it
No,
be?
if this view is to be taken, then my lord, seniority is not to be given a.
That is why, can it be interpreted this way?
Miller.
That once the officers on the zone of consideration are considered by the screening committee, and the screening committee gives its report to the promotion committee, the screening committee report will have to be on the basis of the criterion of merit. Now, when the promotion committee gives its report, then the question of seniority would arise only when they have got equal marks.
We got equal.
If they get equal marks.
We got equal.
If they get equal.
Also all 60, my lord.
No.
So by whatever yardstick we apply, my lord, there is no escape.
Because there is no benchmark. There is no benchmark.
No, my lord. Therefore, my lord, this entire page 179 to 186, my lord, it cannot be left to the sweet discretion of these people who are managing the show, my lord. Some objectivity, some meaning has to be given, my lord. Otherwise, my lord, it is like he is not black, he is blue, then that will be accepted by the court. That is not the purpose, my lord.
And so we'll have to see whether the marks you have got.
End of the day, my lord, they will have to produce the records, that to the contemporaneous records to show how the cases were dealt with, my lord, vis-a-vis the, merits of the case, of each of the persons whose cases were considered. Now, please come to the impugned judgment, my lord, last para. One page, my lord, last para of the judgment.
Second last.
Page 508, my lord, para 52, part of the para 52. My lord, I'll refer to page 507, last sentence, starting of para 52. Reverting back to the present case.
Yes.
Reverting back to the present case, merit and seniority of the petitioner as per promotion policy appears to have been assessed on comparative and relative basis with objective criteria on all the parameters vis-a-vis the eligible officers in scale 6 in promotion exercise in which he participated. However, the petitioner could not make it within the 16 selected officers. Thus, no illegality, much less unfairness is discerned, as the respondents, after taking into account the assessment recommendation of the screening committee, overall merit, suitability, growth potential, length of balance service, qualification, service experience in various functional areas, and seniority of the candidates have assessed from the performance appraisal record as well as personal interview, prepared the list of officers. Lord, the learned single judge has quoted the Milord, the lines from the policy. But Milord, how can it be justified, Milord? That's the whole question. Now a person who is responsible for the company losing 376 crore against the appellant who has earned 85 crore profit for the company, he is ignored and that gentleman is preferred. The person against whom FIR is lodged under section 420 and he is preferred, Milord. So, Milord, how seniority was assessed? How merit was assessed? How interview board dealt with each of the interview board members, DBC members dealt with the issue? These records were never produced, Milord. Normally, Milord, in a certiorari proceeding, if they are feeling shy of producing the records, lordships will draw an adverse conclusion. Now, Milord, I have a better merit. I am senior. And if everybody got 60, then I being the senior most, Milord, I should have given as per 13.1.1. And Milord, what is interview, how much I was given, that I don't know. Therefore, Milord, what we have essayed is the decision-making process. It is our respectful submission that the decision-making process is vitiated on account of non-compliance with the Milord prescriptions in the promotion policy. And secondly, my lord, their averment in the affidavit that promotion at such level is subjective. And that is an aspect, I think, where lordships will have to give a finding, Milord. Whether it is subjective to such an extent that they can even say black or white. And finally, my lord, my last submission is, based on my performance appraisal report, my lord, the screening committee had passed me, has approved my case for further consideration. So therefore, there is no question of, tinkering with that any further. Whatever is there, it is there. Now, my lord, in the interview, how I was treated, my lord, because interview also has a component of 20 marks. So these are the aspects in my humble submission, my lord. Lordship will have to see, my lord.
Yes.
And my lord, the interview board's role would be to, my lord, take the interview, make an assessment and give the marks. Once that screening process is over, virtually, my lord, 70% of the job is done. So that is my humble submission, my lord. Lord, I have made a small note, my lord. Copy of the judgment also, please. That you relied on. I'm relied on, yes, I'm typical. Once, give me.
9.1.
Typical तो दिया है बोला है दूसरा वाला है।
That's only subject. Committee. Commission committee again. Is 13.1.1. Here there are variants. 13.1. See the 13.1. No, next paragraph.
The Lordship's kind permission, Miller. I have one matter in court number, so I'll come to.
No, this will not. Let's see. For insit. 13.1. It's for insit. We are concerned with promotion to points. Eligible officers interviewed by this management shall have an interview for this one. Shall not occur. The assessments for those. Overall merit, suitability, growth potential, length of balance service, qualification, servicing from the performance as may be assessed from the performance as per the records as per. Second book, no, based on the materials. Service. No. Yes. By the promotion. Have to look into it. How would they look? Okay, it's only on the basis of interview or? Only interview, only on the basis. Here for interview. Now they will then.
Just one question before we start.
Please, Manoj.
The assessment to be made by the screening committee, is it subjective or objective?
Absolutely objective.
Objective.
Certain parameters have been laid out.
Okay.
Screening committee marks each candidate on those objective parameters. And that entire record of the screening committee of all 46 candidates was placed before the learned single judge.
What are the criteria?
I'll read that out. It's in 13.1.1.
13.1.1.
13. Sorry, Malas. 9.1. Screening committee is 9.1. Manoj, relevant is at 9.1.2.
Yeah.
Manoj, have that?
Yes.
It's at page 181 of the report.
Yes, got it.
The screening committee shall assess the officers under the parameters of conceptual value, conceptual level / vision, depth and range of overview of the industry / economy, planning ability, decision-making ability, management traits, positive attitude, problem-solving ability, including conflict resolution / management, overall leadership, ability, etc., and submit their assessment recommendations to the promotion committee. They have been marked on all of these parameters separately.
Is this based on an interview?
No, screening, yes. Screening committee is also based on it. What is the name of this thing? Administrative Staff College of India, Hyderabad, has been engaged by the company since many years to conduct the screening process. It's an absolutely independent body and all candidates appear before them, sometimes virtually, sometimes physically. And they are the ones who assess and give these marks under these parameters which are placed before the promotion committee. This has also been recorded by the learned single judge and all of these marks, Manoj.
No, not.
What about service records?
Entire service records of all 16 selected candidates of last 6 years was before the learned single judge.
No. Screening committee.
Also gets a service APARs.
All APRs and everything. Are they looked into by the screening committee?
That Manoj, I can just answer that within a minute. I'll just check that. Check it. I'll just have that checked. This I don't know.
Otherwise, how do you make an assessment?
I would presume that they would have it, but I'll still just confirm.
To make a subjective assessment on the basis of the interview only. To have an objective assessment,
Right.
you'd have to go into the record.
I'll just answer that as well.
And what about that in your affidavit, you have said that word subjective?
Can I answer that first?
Yes, yes.
Before going ahead, Manoj?
Yes, yes.
I'll just show a couple of documents. Because that thing has been hanging on my head as a sword even before the learned single bench. And Manoj, specifically a query was posed to me. If Manoj can just come to my counter affidavit to this writ appeal and have page number 812. Bye-bye.
Yes,
Manoj, have 812.
yes.
Manoj, when this thing was pointed out by my learned senior for the first time before the learned single bench, this order came to be passed. If Manoj will just have heard Mr. KNC, learned senior counsel assisted by so-and-so, learned counsel appearing for writ petition, also heard Mr. So-and-so appearing for respondent number 228, who seeks posting of the matter again after upcoming Bihu vacation so as to enable him to obtain updated instruction and if necessary, file an additional affidavit responding to the query of the court as to the feasibility of production of the relevant records indicating the objective materials based on which the subjective satisfaction has allegedly been arrived at while promoting the selected candidates. Specific query was posed to me and I was directed to file an affidavit, Manoj, which I did. And that affidavit, Manoj, will find at page 455 of the writ appeal. Manoj, may please have page 455 of the writ appeal. Relevant is at page 456.
Yes,
Manoj, have that? Page 456.
yes.
Para 2. That the present writ petition was listed for hearing on 18th March 2025, wherein this Honorable Court raised a query regarding the objective materials forming the basis of the alleged subjective satisfaction, which has been arrived at while promoting the selected candidates in the promotion exercise 24-25. Now, my lords, para 3 onwards, before answering the query, I have listed out all the relevant paragraphs of the promotion policy, which are not relevant. I don't want to repeat that again, my lords. My lords can straight away come to please 461. Page 461.
Yes.
Para 4, that it is respectfully submitted that paragraph 13.1.1 of the promotion policy indicates the guiding parameters for promotion exercise for selection of candidates. The promotion committee conducts an objective assessment based on these parameters in making the final determination. Notably, the promotion committee takes into consideration the performance appraisal records of the candidates for the preceding 6 years as part of the promotion evaluation. The candidates are allotted marks under the following parameters. Manoj will have that. Serial number 1 to 4, work record, which is ACRs of the preceding 6 years, external assessment, seniority, and interview. Further, the work record ACRs, so ACRs are also further broken down into various parameters. And towards those parameters, marks are allotted, which are performance, major contribution, institution building, health, integrity, general assessment, outstanding work, and fitness. And therefore, my lords, para 6 towards the end, I've written that therefore, as established above, there are specific objective parameters that enables the promotion committee to evaluate the candidates for promotion to scale 7 kata. Now, my lords, for a moment, how does the learner single judge deal with this? My lords may have the impugned order at page 502 of the writ appeal.
Yeah.
Incorrect statement has been given before this court that the entire contemporaneous record of the promotion exercise was not presented.
Para 42, we have seen that.
Para 42, I will just read it out, Manoj, just for Manoj's satisfaction. Regard being given to the averment made in para 40 of the affidavit in promotion that by the respondent to the effect that the promotions of such higher level are subjective in nature, given the profile and accomplishment of the candidates coupled with the requirement of the company, I find that the same would be inconsequential as the promotion exercise undertaken by the respondents as revealed from the record appears to have been made on objective criteria in accordance with the promotion policy. Every single document, all mark sheets of the screening committee, mark sheets of the promotion committee, everything, pages running into hundreds of this thing. Multiple envelopes was given, submitted before the learned single bench, and it's being said today that the entire record was not submitted. Is the, my lords, the interpretation for a moment of the learned single bench may be incorrect.
It's okay.
As per their case. But can the finding be incorrect that here the learned single
No,
benches?
it appears that records have been put.
That's right, my lords.
We cannot take a different view.
That's
because
next page, my lords. And my lords, unfortunately, an entirely new case is now being brought up before my lords with absolutely no pleading to that effect in the before the Red Court. Nothing.
Okay, is there any benchmark provided?
No. Number one, no, my lords, benchmark for that answer, I have two answers. One, in their own additional affidavit, which they have relied upon at page 800 and I'll just read that out, my lords. Page 862, in which, my lords, they've given that scheme of weightage.
Correct.
The 4 parameters that I just made, my lords, read in my affidavit, they somehow seem to know the marks. Even though that record was only for the eyes of the learned single judge, they seem to know the weightage that each parameter carries. This was never supposed to be disclosed to them. So 60, 10, 10, 10, 20.
The total marks.
Total marks. And that 60 further is broken down in the larger parameters that I had read out.
No. That 60, what do you mean that 60? You mean
60
that
towards APAR, my lords.
APR will be APR
Work
is
record.
60.
Work record 60 is further broken down into multiple parameters, which I had read in my affidavit just now. My lords, this
no benchmark as such.
No benchmark, number one. And number two, my lords, the 16 promoted candidates, all of them did not score 60. That statement can be recorded today. All of them did not score 60. Third, my lords, the only case that was presented before the learned single judge was this: I am meritorious, I deserve to be promoted. Crux of their case. My lords, is he meritorious? 100% he is meritorious. Not even for a moment am I saying he is not meritorious. But I have to, as per my policy, go into comparative merit. I have to assess comparative merit and then see that what are these candidates that fall as per the number of vacancies that are available. Has he been given exactly the same marks as his peers have been given in intersectionality? Yes. Has there been any arbitrariness that has happened? Nothing.
There's no malafide.
No malafide, neither alleged nor ascertained by the single judge. And my lords, very interestingly, what needs to be seen is fundamental right of consideration is there. Fundamental right of promotion is not there. Multiple judgments are not. But my lords,
Just tell us one thing. The marks. What was his position
in the marks, my lords?
Yeah.
I'll just
mark secured? Less than the persons who have been promoted. Is it?
Sorry, my lords?
Less than the persons who have been promoted.
16 have been promoted, 47 were part of the ZOC.
Yes, 47 were considered.
16 were promoted and he was at serial number 90.
90.
Now, my lords, just two things I also want to answer before I go into the record, my lords, because this has been said multiple times by my senior friend today. He has generated profit. So-and-so person has generated loss.
Correct.
Two things. In an insurance business, which is a competitive business, specifically this is a PSU insurance company, there are private players in the market. Different areas have different sorts of businesses that come to insurance companies. Now, for an example, the person that he is pointing out has suffered 10 rupee loss. In the previous year, his predecessor was suffering 12 rupee loss. So by suffering 10 rupee loss, there is an improvement. But if he has incurred, has gained 10 rupee profit, but his predecessor was gaining 12 rupee profit, he is now doing worse. So in a competitive market like insurance, this particular aspect that who has, today I post, Mr. The petition has been posted, has been given foreign postings at good positions, good markets where good premium is generated. I post him in some godforsaken place, in some small village town. There'll be no profit generation out of that. Because all of these Fasal Bima Yojanas, all of these schemes of the government, which have large claims in quantities, when they will fall on that particular branch, that branch will have to suffer losses. So this is an argument in the air, completely, and not pleaded before also. And second, Manoj, he pointed out that there is an FIR against a person who has been, Manoj, because I need to answer everything. There's a closure report on that FIR today. Even on the day of the promotion exercise, there was a closure report.
Closure report on
that FIR.
respondent number 9.
Against the respondent number 9. There's a closure report.
The matter has been responded back to the.
There's a protest. Please, sir,
Yes,
please.
yes.
There's a protest petition pending. So prima facie, the police after investigation has submitted a closure report before the magistrate court. But these things, see what has happened is, Manoj, most respectfully, since day one, the petitioner has wanted to sit as a monitoring committee on the entire promotion exercise. His representation to the company was, show me all the record. I will sit down and decide and to let you know what you have done incorrectly for these 47 candidates and how my name will feature in this top 16. Then he doesn't get that from the company, so he comes to court. Court, his entire praise is only this: quash the promotion exercise, not challenging the promotion policy. So there's absolutely no challenge to 7.2. Manoj, the only paragraph of the policy which was not read by my learned senior was 7.2, and that is what my policy is. My policy is merit, sole criterion of merit. And of course, I can't ignore 7.1. So I have to give relevant respect to the seniority, which I do. It is one of the parameters on which they all are marked. All 47 have been marked. So Manoj, we have to be fair. At the end of the day, he cannot choose to become a monitoring committee. Of course, Manoj, separately, one of my legal arguments that this honorable court also has certain restraints as far as judicial review in matters of administration of a PSU company is concerned. Manoj, given all of this, can I just read out 4 paragraphs of the impugned judgment? And I'll not trouble my lords further with each argument. Para 37 onwards, Manoj, it's at page... Sorry, Manoj. Manoj, the impugned judgment starts at 489.
Just on.
Before I go there, I'm sorry, just one small point that I missed out. My learned senior also laid a lot of emphasis on tweaking of the promotion policy.
Yes.
Of reducing the minimum required years from 2 to 1.5 months. Manoj, for a moment, if I can just request Manoj to come to his writ petition, page 76. Writ appeal, page 76, is his writ petition before the learned single bench, para 25. Let's have page 76, para 25 minutes. His writ petition. That the petitioner begs to submit that it is the second time the petitioner has been denied promotion. On the earlier occasion, the respondent authorities had issued notice on so-and-so for filling up 16 vacancies as per 18th amendment to the promotion policy. There was discontinuation of in situ promotion so-and-so under para 13. And also there was a relaxation of eligibility criteria. Manoj, please mark this. Wherein the minimum completed continuous service in existing cadre was reduced from 2 years to 1.5 years, despite the petitioner being eligible under the amendment criteria. Because he himself in the promotion exercise preceding the one that is under challenge had benefited and fell into the zone of consideration only because of the amendment to this eligibility criteria.
So petitioner also took advantage.
Took advantage, never challenged that promotion exercise.
though he did not get promoted previously as well, but he himself is a beneficiary of this amendment. So the tweaking that has been today, I mean, my lords, given that color of arbitrariness and biasness, the petitioner himself has benefited from this as per his own pleading. So today to conveniently read part of the promotion policy and say that it is merit cum seniority and seniority, I'm sorry, it is sole criterion of merit. Seniority needs to be respected as per 7.1. Now, my lords, to draw an analogy, if my lords may give me a minute, I will also read clauses of the promotion policy which are applicable to officers up till scale 5. So scale 6 and scale 7 are the highest posts. Up till scale 5, specific regard explicitly towards seniority, not only how it is to be taken care of, what marks are to be given is provided under clause 11, paragraph 11 of the promotion policy. If my lords may, I will just point that out. That's at page 182 of the writ appeal notes. 182 of the writ appeal notes. I will just read that out. My lords have paragraph 11.
Yes.
Scheme of weightage to various parameters in the criteria for promotion up to scale 5. And my lords will mark in 11.1 there is a table.
Yeah.
In that table, my lords will see serial number D, seniority.
Yes.
And we'll see subsequent columns, my lords. Scale 1 to scale 2 is to be given 40 marks for seniority. Scale 2 to scale 3, 35. Scale 4 to scale 3 to scale 4, 25. And scale 4 to scale 5, 50. So as the seniority goes, the marks for seniority are actually reducing. And then, my lords, relevant is on the next page, 183, which is 11.5, my lords may have. My lords have 11.5.
11.5.
11.5 towards the bottom of the page, my lords will find it. At page 183. Seniority.
Yeah.
Evaluation for the parameters of seniority shall be done as under. Marks for completed years of service shall be allotted as under. Again, the same marks descending order as I showed in 11. To give weightage to inter-se seniority amongst the officers belonging to the same batch. That's very important. 11.5.2. To give weightage to inter-se seniority amongst the officers belonging to the same batch, 0.01 marks will be added in the ascending order, starting with 0.00 for the last officer in the list.
What does this mean?
So, my lords, hypothetically, if there are 5 officers of the same batch, but are inter-se there is seniority, so the junior-most person will get 0.00. One person senior to him will get 0.01, 0.02, 0.03, 0.04. What I'm trying to demonstrate from this is that the policy is so comprehensive that where seniority needs to be marked, they have even taken care of this aspect. That even in a list of seniority, when inter-se juniors will fall together in one batch, and this happened in this case as well. In the column where the petitioner fell, there were 10 others, but they were all given the same marks. And in fact, this aspect was even investigated by the single judge, that even if this 11.5.2 was to be applied, and we were to give 0.00 to 0.01, 02, 03 marks, still he would have not made the cutoff. So when the matter has been heard at length over hours, over multiple days before the learned single bench, the record which was running into thousands of pages has been seen. Today, to make a statement, a record was not available. I now want to read those 3 paragraphs of the impugned order, which is at page 500. So, thoda sa. Let's have page 500 of the writ appeal.
Yes.
Para 37 is where the reading starts. On a cogent reading of the above provisions reflects that the promotion of officers from scale 6 to scale 7 shall be within the 6 GIPSA member companies on the basis of a single seniority list of all officers in scale 6 in all the 6 companies taken together. Promotion shall be based on the sole criterion of merit. Now, para 38.
on bare reading of the clause 13.1.1 clearly reflects that an eligible candidate, after being interviewed by the screening committee, would appear before the promotion committee for interview. Promotion committee shall, after taking into account the assessment recommendation of the screening committee, overall merit, suitability, growth potential, length of balance service, qualification, service experience in various functional areas, and seniority of the candidates, as may be assessed from the performance appraisal records as well as personal interview, prepare a list of candidates selected for promotion. Now, my lords, his observation, learned judge's observation. Thus, in my view, while seniority would be a factor entitling a candidate to fall in the zone of consideration, no dispute on this. But once so empaneled, selection for promotion would be based on merit, as the promotion policy shows that it provides for a structured and merit-oriented framework for career advancement aimed at rewarding performance, fostering leadership, and cultivating a professional culture of excellence, accountability, and commitment, while seniority is duly respected as per 7.1. Para 39. Record reveals.
For 7.1 is not here.
No, that's absolutely. That was my submission, because 7.1 was given emphasis by my learned senior. That was. Record reveals that the promotion exercise has been undertaken taking into consideration all the parameters for selection of candidates for promotion from cadre of scale 6 to scale 7. Altogether, 47 scale 6 officers in the zone of consideration were screened.
47 to
47 were there, but 46 were screened. 40. Well, this has been incorrectly recorded. 48 were the total number of candidates, but 47 were interviewed. Okay. Sorry, minutes. 47 officers in the zone of consideration were screened and interviewed. The promotion committee appears to have conducted an objective assessment based on all of the above parameters in determining the final selection, as the performance appraisal records of the candidates of preceding 6 years as part of the promotion evaluation, and allotted marks on work record, external assessment, seniority, and interview has been considered. It is seen that work record constitutes a major contribution, institution building, health, integrity, general assessment, outstanding work, and fitness. Well, this is the breakup for the work record, the APR, further broken up. It also reveals that Administrative Staff College of India, Hyderabad, was engaged by the respondent to conduct the screening of the impaneled officers. 40 minutes. The record further reveals that each of the parameters were assigned marks. This has been seen and verified, my lords. And the and the candidates were awarded marks based on the performance against these parameters, and the total marks obtained by each candidate were arrived at, and the selection and promotion has been effected. Thus, an objective assessment on all the parameters that enables the promotion committee to evaluate the candidates for promotions to the scale 7 cadre by applying the same norms to all eligible scale 6 officers appears to have been undertaken equally in terms of the promotion policy. Equally, my lords, just pausing here for a moment, same norms have been applied. There is absolutely no arbitrariness or biasness or no tweaking of absolutely any parameter or any norms as far as the petitioner is concerned. In the course of hearing, having found that equal marks have been awarded to the candidates in seniority 4 to 17 of the final mark sheet, this is that what I was explaining, 0.00 inter-se seniority marks. This court posed a query to the respondent as to how equal marks were awarded to those candidates when the petitioner is senior to the other candidates as serial number 15 to 17. To which the respondents have submitted that equal marks awarded to impaneled candidates from 4 to 17 in the final promotion mark sheet, that is the petitioner and his other batchmates from scale 6 stem for the fact that all of them were promoted to scale 6 in the same year. So, my lords, they all fall in the same basket. So, up till scale 5, everything is separate. Now, when multiple batches candidates fall under the cadre of scale 6 in a single exercise, then their inter-se seniority of batch is gone.
1.002.
Even applied would have not made him, but is not applied here. Here now, seniority marks are given batch-wise. So, a person of 21, 22 batch gets 1 point, the next gets 2, next gets 3, next gets 4. So all persons of the same batch secure the same points as far as seniority are concerned. This is what has been done. Stem from the fact that all of them were promoted to scale 7 in the same year under the same promotion exercise and hence possess identical tenure in that scale, which determines the seniority equivalence and therefore entitles them to equal marks for seniority.
Not exactly, not exactly correct. Okay.
Plus,
Slightly, because it cannot be identical.
this may have to be read with the fact that each promotion
Ah.
has to be considered as a fresh employment. Plus, that law is very clear.
No, I'm saying because that 0.001, 0.002, that will come into play.
That could have been, and therefore, my lords,
Not clarified very clearly because they're taking a general term.
I go down now. And just to add that even if that 0.00 and 01 would have been affected to this mark sheet, still he would have not made the cutoff. This was duly considered by the learned senior. And therefore entitles him to equal marks for seniority. This court finds such submission justified as the final determination of a promotion is based on a comparative merit and seniority on an objective assessment on all the parameters in terms of the promotion policy. Regard being had to the averment made in para 40, of this I've already read with regards to the subjective, I will still read it out. Regard being made had to the averment made in paragraph 40 of the affidavit in opposition by the respondent to the effect that the promotion at such higher levels are subjective in nature. Given the profile and accomplishment of the candidates coupled with the requirement of the company, I find that same would not be the same would be inconsequential as the promotion exercise undertaken by the respondents as revealed from the record appears to have been made on objective criteria in accordance with the promotion policy for the officers. Then, my lords, certain judgments are discussed. I'll not trouble my lords with that. And straight away coming to the concluding paragraphs 52 and 53 minutes, which my lords will find at the end of the page 507.
Yeah.
Reverting back to the present case, the merit and seniority of the petitioner as per the promotion policy appears to have been assessed on a comparative and relative basis with objective criteria on all parameters vis-a-vis eligible officers of scale 6 in the promotion exercise in which he participated. However, the petitioner could not make it within the 16 selected officers. Thus, no illegality, much less unfairness is discerned. As the respondents, after taking into account the assessment recommendation of the screening committee, overall merit, suitability, growth, potential, length of balance service, qualification, service experience in various functional areas and seniority of the candidates, have assessed from the performance appraisal records as well as the personal interview, prepared a list of officers selected for promotion and issued the notice of promotion for 16 officers. In view of what has been discussed above, I am of the considered view that there is no procedural infirmity or illegality in the promotion exercise, and therefore no interference warranted in the notice headed so and so. One small aspect also that needs to be appreciated by my lords is this, that the same promotion policy, the same parameters, the same exercise in its entirety, the petitioner has gone through when he came from scale 5 to scale 6. No challenge. Same parameters, same marking system, same absolute identical policy in place when the petitioner came from scale 5 to scale 6. But suddenly, when he does not make it from scale 6 to scale 7, the same policy has 100 flaws. So till the time he benefits, no problem. The moment he does not, then the tweaking comes into place. I believe I've answered almost all of the points that my learned senior had brought up. Now, if I can just show some judgments. Before that, the last additional affidavit that the petitioner had filed in the writ appeal, I had only filed a response to that additional affidavit as an objection. It only had my legal objections because, my lords, at least before the Delhi High Court where I practiced regularly, no additional document can be brought on record at the writ appeal stage without the leave of the court or without a proper application submitted. This is the affidavit by way of which they have brought on record the FIR, the comparative analysis of the loss and profits. All of those things have been borne out in this additional affidavit. I will just point that out.
5/8/2025.
No, 30th August. No, sorry. This one. 31st जुलाई को आपने फाइल किया था. Now this affidavit starts at page 509. The response to which that I have submitted before this honorable court, I have not given any reply or any response on merits because I have made an objection that these documents cannot be gone into, whereas no application has been filed in support to bring on record additional documents and a new case is being voted. So unless that hurdle is crossed by my learned senior, if he wants to rely on that, those aspects cannot be gone into by this court entirely.
So, here, he has brought, he has brought into, he has brought how many documents?
Three documents.
And your objection on merit.
One is the court order, my lords, that may not be seen. Annexure 2, poly, and Annexure 3. Page 525 is Annexure 2, and page 532 is Annexure 3.
So what your objection is against all 1, 2, 3.
That's right, my lords. What I have basically said in my objection, which has been filed on, which my lords will find it, sorry, on 9 September, my lords, it's been filed starting at page 535. That is my response, my lords. Affidavit in opposition. In this, I have only taken a legal objection, my lords, that this additional affidavit needs to be struck off the record of the honorable court and cannot be gone into, including the documents. Judgments. Because, my lords, repeatedly during arguments, it was said that this has not been responded to. This affidavit has not been responded to. This aspect has not been responded to. There is a reason why it has not been responded to. In fact, I have craved the leave of this honorable court in my response that in case my lords are to accept his request and have these documents placed on record, then a chance be given to me to file a response on merits, which I haven't done as well. Lords, on the judgments aspect, this one. Lords, I will only pass on the citations.
Yes.
Once more, for a second. No, copy. Manoj, judgments 1 to 3 are only on the aspect that promotion cannot be claimed as a matter of fundamental right. I will not read the relevant paragraph. Can I request Manoj to just come to judgment number 4? Judgment number 4 months. Relevant is it? Judgment starts at 128. Relevant is at 133.
133.
133. I will just read 3 paragraphs.
Yes.
Let's have paragraph 9.
Yes.
As the figurative data extracted from the policy goes to show, the service structure is like a pyramid. The higher one goes in the ladder of promotion posts. Remarkably, the seniority loses importance and the merit gets primacy. In Syndicate Bank case, observations in para 14 throw considerable light on the controversy. The third mode, apart from seniority cum merit and merit cum seniority modes, has been recognized. It has been described as a hybrid mode of promotion. In other words, there is a third category of cases where seniority is duly respected and merit is appropriately recognized. While laying down the promotion policy or rule, it is always open to the employer to specify the area and parameter of weightage to be given in respect of merit and seniority separately.
So what is your case? In this case, is it the third mode, the hybrid mode, or is it the?
Is the third mode, but has to be read the other way around. Because actually, my policy says merit is the sole criterion, but I have to give due respect to the seniority. So I can't completely ignore seniority. That is what my mode is. And therefore, it's a version of the hybrid. But merit is the sole criterion. I cannot run away from that.
But that way, when you say merit comes seniority, they're also the same thing.
No, Manoj. Merit comes seniority. In the mode of merit comes seniority, seniority has to be given a lot of weightage. Here it is not like that. Here the sole criterion is merit. One line that I want to say is the policy is not under challenge today. So we actually don't have to go into the fact whether the policy wording or the mode or the means of the.
Fourth and fifth and sixth and seventh, what are these?
These are all on scope of judicial review and administrative matters.
That's all.
And separately, Manoj, I have two judgments which are on the aspect of that no new case can be created at the appellate stage, which my learned friend.
Already in your. Okay.
Manoj, the judgments are here. And that pleadings which have not been taken before the writ court cannot be taken at the time of filing a writ appeal. Because much has been said here, which was not present before the learned single judge. And therefore, my lords, in my respectful submission, the learned single judge, after having examined all the entire record of the promotion policy proceedings, has come to this conclusion. And before this appellate court, my lord should not interfere with the order that has been passed by the lords.
Well, Lord, I'll have to give a reply in 10-15 minutes.
Then my lords,
No, but first thing-
5 minutes per
No,
sir.
the first thing, my learned friend has referred to his fourth judgment. Kindly see what was the facts of that judgment, my lord. What was that case? Court was interpreting what is the meaning of merit cum seniority. What relevance that judgment has got in our case? Not every case is a decision, is an authority for what it actually decides. Secondly, my lord, he says about that affidavit. Please read para 8 of that affidavit, my lord. Under what circumstances that affidavit was filed? Why it was filed? Kindly see para 8 of that affidavit.
You'll take how much time?
10 minutes.
10 minutes,
Yes,
not more than that. We're going to put you on the clock.
10 minutes.
Because we've got other matters also.
No, only
We've
10
taken
minutes.
a lot of time.
Only 10 minutes. And my learned friend says, my lord, that we have not challenged the policy. Why should I challenge the policy? I'm banking on the policy. And when I got promoted under the same policy, then it was good. Now it is bad. That contraries my argument. I said, this is so objectivity is there. If you follow it, then this result cannot happen. And my lord, our High Court, there is a division bench judgment, my lord, GC Sharma versus BRPL.
Can I get a copy?
Where this, every time I don't carry a copy.
No, but you're quoting a judgment.
GC Sharma versus, you'll get it. My lord,
Well, just like my learned senior is commenting that the facts don't apply to the case, I can only read the judgment and say something.
It's a judgment not of this. It's a judgment now.
of the Supreme Court.
That's right, my lords. But if he's relying on something, I can request for a
No,
copy.
of course you can. No, my lord. See, when I'm on legs, please take your seat. Okay, you'll get your turn and say as much as you like. Don't stand up when I'm parallelly standing up.
Yes, Mr. Chairman.
My lord, my humble submission is, now, my lord, these submissions, my lord, what relevance does this have, my lord? Now, my learned friend has repeatedly made one submission, entire record was placed before the single judge. Please place that entire records again now. Then lordship will get to know.
That we will decide whether
Yes.
it's required or not.
No.
Because one thing, you had
No, my
taken
lord.
the stand.
No, my lord.
No,
Lordship will
just
kindly listen to.
taken the stand that the records were not produced before the court.
Yes, contemporaneous records are not produced.
But the single judge has said that it was produced. In many.
No, my lord, they have produced only that sheet. They themselves said we don't maintain these records. No, my lord, end of the day, lordships will take a call on our submissions. I am not on that. Now, what is our argument? Our argument
We will
is,
take it up.
okay, 10 minutes.
Yes.
I think my learned friend wants to make a mention.
Lordship, I beg to mention item number 6. We are appearing on behalf of the respondent. We are supposed to file the affidavit in opposition, but the official, this matter is related to NIA Imphal branch. And the official, he is supposed to arrive tomorrow. So it is.
Who's for the petitioner?
Nobody is there. Lordship.
Last date there was nobody.
Last date also there was nobody.
On the last date, they are ready.
Okay, you wait for some time, how does it work? If they keep on being absent, we'll dismiss their petition.
Wait, Peter. My Lord, I'll just take 10 minutes time, Miller. If a lordship could kindly take the impugned judgment, Miller. Let us see, my Lord, from what perspective the learned single judge has decided the issue. Please come to, my Lord, page 500.
Yes.
Para 38.
Yes.
On bare reading of clause 13.1.1 clearly reflects that an eligible candidate, after being interviewed by the screening committee, would appear before the promotion committee for interview. The promotion committee shall, after taking into account the assessment recommendation of the screening committee, overall merit, suitability, growth potential, length of balanced service, qualification, service experience in various functional areas, and seniority as may be assessed from the performance appraisal record, as well as from the personal interview, prepare a list of the candidates selected for promotion. So far, so good. Now kindly see me. Thus, in my view, while seniority would be a factor entitling a candidate to fall in the zone of consideration, but once so empaneled, selection for promotion would be based on merit, as promotion policy shows that it provides for structured and merit-oriented framework for careers advancement at the aimed at rewarding performance, etc., etc. So, my Lord, the learned single judge, the premises on which the judgment has been structured is seniority is a component which will determine the zone of consideration, nothing beyond that. So that, in my humble submission, is absolutely wrong. So it is in this perspective, Lordship will have to find out whether the eventual conclusion of the learned single judge is therefore right or wrong. I'll not trouble your Lordships again and again. I have already read page 186, where it says, my Lord, seniority will also play a role at the stage of determining whether somebody's name should be in the promoted list or not. It's not that seniority is a component only for determining the zone of consideration, as has been held by the learned single judge. Now, my Lord, my learned friend has made a submission that petitioner's mark is not equal with others. I think that submission my learned friend has made. And he has also sought to dispute that, have you got 60? No, I have not said that one. He has attained the maximum marks in APAR. I said in the 16 selected candidates, some have not. He has gotten the maximum marks in APAR. Work record is 60. That means I got 60. Yes, he did. In merit. So did I, because I never disputed that. Then, my Lord, if I have got 60, then if I am equal, now let us see the second perspective of the learned single judge. My Lord, there's a lot of errors, my Lord. Now, my Lord, will kindly come to page 507, para 51, last sentence. Page 507, para 51, last two sentences. Because the judgment on the proposition of merit cum seniority was, my Lord, pressed into service. Now, what is the view learned single judge has taken? Seniority is to be given weight only when merit and ability are approximately equal. Thus, in my view, same would not come to the aid of the petitioner. My lord, if the merit is equal, then by virtue of I being senior, it will play a role. Now, which is that? Where is that? Where the DPC has considered that as well? Well, it can't be that I would be denied on all front. On one hand, you have taken the view that it is seniority will only give me a place in the zone of consideration. Other than that, there is no role. Here you are saying that seniority will be relevant when the merit component is equal. Merit component is equal. Again, my lord, just now we have checked the video of my learned friend's argument before the single judge, where he clearly said that I have got the maximum, that is 60. That's all. That I have got it.
No, I think he's saying that besides APR, there are other factors. which have to be-
Exactly. Exactly. Therefore, it boils down to interview. Now, what is the mark I have got in interview?
Let us see
No,
the,
not- I cannot question how much mark has been given to me, but I can certainly question if the promotion policy was not correctly perceived by the DPC.
this is the chart you gave.
Yes, Milord. Page 862. 862, yes, yes. 862.
Para 44.
Yes,
So work record, he's got
60. That's right, Milord.
So now we have to see whether he's got seniority also probably 10. We'll have to see with regard to screening
Screening,
and interview.
interview.
Seniority, he would not have gotten 10 because there are people of batch senior than him.
Okay.
So they would have gotten more marks. So he would have gotten a reduction.
There were only 3 people above me.
So in fact, my lords, even people who were senior to him have not made it in the promotion. But they're not here.
No, that is not the issue.
No, I'm putting it to my lords.
But only, my lord, the zone of consideration 1 and 2 were above me. The rest are all below me. Now, regarding the other point, my lord. Yes. My lord, therefore, on this count, my submission is, my lord, since on merit we are equal, seniority has to play a role, and lordship will see from the records how that component was dealt with. So that, my lord, if your lordship is satisfied that no, I have been fairly dealt with, end of the matter. If your lordship come to the conclusion that no, there is something wrong, then lordship will direct a review DPC. Now, my lord, regarding that affidavit, my learned friend's submission, that the practice in Delhi High Court, the practice here is also same, my lord. And by the way, my lord, there is a judgment, I'll come to that. Before that, if your lordship will kindly come to para 8 of that affidavit, my lord. Page 517. Para 8.
Yes.
That it is respectfully submitted that the contents of the present additional affidavit, along with the documents annexed hereto, bear significant and material relevance to the issues arising in the present writ appeal and are imperative for a just and fair complete adjudication of the matter.
Yes.
The appellant has placed on record certain materials which were either not within his knowledge at the time of filing the writ petition or could not be brought to the notice of the learned single judge due to deliberate non-disclosure of documents by respondent authorities during their earlier proceedings. The production of this document is therefore not only justified, but necessary in the interest of justice. So in a sense, my lord, we have sought for a leave also, my lord. So
Anyway, just I think you have anything else
no,
to add?
just one judgment, my lord. Ada copy for the Dila? My lord, in GC Sharma's case, my lord, I argued the same thing which my learned friend argued. Learned single judge upheld my contention. Division bench, my lord, said no. A plea was abandoned and which was sought to be taken before the division bench. Please come to para 22.
Yes.
Learned Additional Solicitor General has submitted that since the Learned Counsel for the respondent writ petitioner has already abandoned the plea of perversity, that the finding is perverse, the same is not open for the Learned Counsel for the respondent writ petitioner to place again before the division bench of the High Court. Since writ appeal is in continuation of the original order passed in the writ jurisdiction by the Learned Single Judge, it cannot operate as an estoppel against the Learned Counsel for the respondent to praise the same. So since it is a continuation of the original, yes, my learned friend is correct to the extent normally we should take a leave from this honor. To that extent, I agree. And that is in all fairness, that is the.
Anyway,
So therefore, my humble submission, thus I'm concluded. Sum up my argument, here is a case, in Learned Single Judge Milord, somewhere Milord has gone wrong in taking the view that seniority is a factor which is relevant only for deciding the zone of consideration. No. Secondly, Milord,
yes,
and Milord, in the brief note which you have given today, Milord, based on the proceedings of the Learned Single Judge, we have also said in external.
just one thing, we're not concluding. We just want the marks
Yes,
for that screening and that interview.
yes.
For the petitioner, my lords?
All. You just give us just give us the marks with regard to para 44 of 860. You don't have to bring the record, original record. We'll believe whatever.
My lords, may permit me to file it in a seal cover.
You sure the seal.
My lords,
Give
may
me the
state in the order, I'll file it in a seal cover within 1 week.
Yes.
I'll file.
They give in a seal cover.
Yes.
All the marks taken by all the candidates to work.
Just the
on
16 or the 48 minutes?
Seniority.
16 or 48 minutes? The entire ZOC or the?
Yes, till 20.
I'll give it.
Till 20. 1
No
to
problem.
20. Well, he's in 19.
He's at, yes,
Well,
he's
give
at.
the whole, give all. How does it
I'll
matter?
give it to 48, no problem.
Give all.
As long as it's in a seal cover, absolutely.
It'll be
my lord.
47.
I have-
47.
It'll be 47 because
I'll give it.
48 was the person. So work record, seniority, screening interview, and you also can make a chart, separate chart.
I have that chart.
Okay, you have the chart.
I have a ready chart prepared as my lord wants.
I just show us that.
I'll file it
When?
within a week. My lords, I'll have to go back.
This bench will not sit unless you put it partnered.
Otherwise, my lords,
Actually, Milord, Lordship has taken so much of time. What happened?
It's like a Damocles sword hanging over us.
Domical sword.
Can you, what about Friday?
Friday?
Possible? It's just that marks, we just have to see. We have heard you all. I mean, there's nothing else to hear.
I'll bring it by Friday, my lords. I may not be able to file it. I'll bring it in a seal cover and I'll hand it over to my lords.
Yes, that'll do. You don't need to come.
I may not be able to file it in the registry in time.
No, you can just hand it over to us in a seal cover.
I will do. On Friday, by Friday, I will.
I will give it back.
By Friday, will.
We might reflect the marks that.
Well, just one last thing I want to point out, because repeatedly again, my learned senior said that. Well, I can just have the impugned order, the paragraph that sir just named.
51.
51. Can you, Manoj, just for a moment, Manoj, just I want to page 501, Manoj.
Yes. 507.
Just 1 second, Manoj, please. Just 1 second, please. Sorry, Manoj, actually. I've gone back to the writ. Page 501. Third line. The argument that has been made in the beginning and now again repeated twice is, while reading the observation of the court, that thus, in my view, while seniority would be a factor entitling a candidate to fall in the zone of consideration. So the argument being made again and again is that seniority has only been considered up till the time the candidate fell into the zone of consideration and not thereafter. This entire paragraph has not been read. I will just read this entire paragraph. But once so empaneled, selection for promotion would be based on merit, as the promotion policy shows that it provides for a structured and merit-oriented framework for career advancement aimed at rewarding performance fostering leadership and cultivating a professional culture of excellence, accountability and commitment, while seniority is duly respected. So seniority is also duly respected when that thing is considered.
We're not on that. You see, we're on the basically on page 862.
Please, Manoj.
Where the parameters are laid down on which you're going to give marks. So we just want to see that if that has been followed, there's nothing to say beyond that.
Interestingly, Manoj, just one small clarification. Manoj would want the cumulative marks given by this screening committee and the interviewing committee, or the breakup of the different or the entire breakup of both the committees. Manoj?
You give us the breakup of the main committee, the promotion committee, the
Right.
breakup given.
For each parameter.
For each parameter.
I will give.
That is the main, that is the basis of the
list.
promotion.
For the screening committee, I'll also mention the marks, whatever screening committee has.
Screening committee, what marks has been given for each of the candidates, we give that. Yes, it should be there in the breakup itself, could be, I don't know. We don't know.
I will make a comprehensive chart, it'll be self-explanatory.
Okay, right.
My lord, one,
Should not prepare.
my lord,
Because not a.
my lord, instead of they preparing a chart, let the original thing be produced. Yes.
Original can be produced.
Whatever you say, Manoj.
Original.
Again, I'm going to go back to,
Prepare a chart also, but you bring the original.
Yes.
I'll bring the original final mark sheet.
Yes,
The original final mark sheet.
correct. Of all the candidates.
There's a single mark sheet.
Whatever.
Final mark sheet is a single mark sheet. Because then my learned friend will start going into DPC comments of each committee member, and because he wants to sit as a monitoring committee,
I never asked for that. Never said that.
Anyway, you all can ask for anything, both of you can ask for anything.
I never asked.
It doesn't mean that we're going
Please,
to
Manoj.
give whatever you
I will
ask.
satisfy Manoj.
As much record.
Thing is given what you want.
No, my lord. My only,
Thing is not given. Some things are given, some things are not given.
our only concern is they must show that my case was duly considered. And it can be shown only by producing the record.
Anyway, right. Heard Mr. K. Chaudhary, learned senior counsel for the appellants. And assisted by Mr.
SP Sharma.
SP Sharma. Also heard Mr.
Zoravar Singh.
Zoravar Singh.
Respondent numbers 2 to 8.
Who else? Who is 1 and 2? No one. Okay, right.
So there is no relief sought against one Union of India.
The appellant.
One is Union of India. Manoj, I am for 2 to 8.
But this private.
Mr. K. Fukan. MS K. Fukan, CGC appears for fund number. Right.
Money
And the appellants, who is the writ petitioner, has put to challenge the judgment and order dated 3/6/2025, by which the prayer of the petitioner for, what is your prayer?
My lord, for setting aside the impugn selection and directing a review DPC.
For setting aside the impugn selection and promotion of the private respondents and having a review DPC had been rejected by the learned single judge. Good stuff. Next para. The appellant's case is that in terms of the promotion policy as laid out in 7.1, 8.1 clause, the 9.1.1, 9.1.2, 13.0.1.3, and 13.1.1, the selection process for motion of a grade 6, what is it called?
Scale 6.
Scale 6. Okay, promotion of officers from scale 6 to scale 7
Cadre.
of the
Respondent, Malot,
of the what organization?
respondent number 2.
Of the respondent number 2.
Sorry, Malot. Respondent number 3.
Respondent number 3 requires that requires merit and suitability should be given with due regard to seniority. First one. The learned. No, the next para. The appellant's further case is that the appellant has been superseded for promotion to scale 6 on 2 occasions, that is in the financial year 2022-2023 and 2023-2024. It is the case of the appellant that in terms of the promotion policy for selection of candidates for promotion to the scheme for weightage of marks to be given are as follows. The parameter on which marks are to be given are as follows. Number 1, work record dash 60 marks. Number 2, seniority dash 19 marks. 3, screening dash 10 marks. Interview dash 20 marks. First up, the appellant's counsel submits that when the appellant been given 60 marks, had secured 60 marks under the parameter work record, the appellant being senior to which respondent? To all the respondents.
No, my lord, excepting for respondent number
All the respondents except respondent number
7 and 8, and then 9 and 10. 9 and 10.
9 and 10. There was no ground for the respondents to have promoted
9 and 10, 9 and 10.
the respondents number 9 and 10 over the appellant.
No, I will Chandra. I need Chandra say.
Actually, next part. The next part, the appellant's counsel submit that a perusal of the pleadings would show that the respondent number 9 during his service career and made a loss for the concerned company, while the appellant had made profits for the concerned company. As such, there was no rationale, no ground for the respondents to have promoted the respondent number 9 over and above
May I just,
the appellant.
my lord, it's respondent number 12, where with the regard to loss, and respondent number 9 with regard to FIR.
Instead of 9, sir. In respect of respondent number 9, the appellant's counsel submits that the said respondent number 9 having a criminal case against him. Wait, which page?
Page additional affidavit, my lord. My lord, 532. The FIR.
That's 6.15.
532, man, annexure 3. And statement is 516, man.
What have I said? Having an FIR arising out of FIR number 0027 dated 17/1/2020 under section 420/34 IPC. The said respondent number 9 could not have been promoted over the appellant, who did not have any criminal case against him. Any other points?
And with respect, respondent number 12, that, those two are the 2 points.
Those are the only points. No? Okay, nothing else. So stop. Yes. Huh? Next. That's all I think. Next. The learned counsel for the respondents number 229.
228.
228, on the other hand, submits that the promotion of officers from scale 6 to scale 7 is to be made on the basis of clause 7.2 of the promotion policy. In as much as as clause 7.1. And wait, and seniority would have to be duly respected only in terms of clause 7. He submits that a reading of clause 11.1 and 11.5 would go to show that the marks to be provided under the parameter of seniority has been given importance only in respect of promotion from scale
1 to 5.
1 to 5 and not for scale beyond scale 5. Though the same is to be respected. Next paragraph. The learned counsel further submits that the appellant has not challenged the promotion policy as on date, and the appellant had also been promoted to scale 6 from scale 5 on the basis of the existing promotion. He also submits that the appellant has now brought out a new case in the writ appeal, which was never an issue for the learned singers. In this respect, the learned counsel for the respondent number 228 has submitted that the FIR number 0027 17/1/2020. And the other documents mentioned in the affidavit, additional affidavit filed by the appellant on 57/2025. Cannot be permitted to be agitated in this writ appeal as is a settled principle of law that the court cannot create any new case at the appellate stage, either of the parties. When there is no complaint having been made before the learned single judge. Anything else?
Plus, in addition, I also stated that the FIR has otherwise been, there's a closure report.
Because the learned counsel for the private respondent also submit that the FIR has been
There's a closure report filed in respect of
has
the
been that has been that report has been filed in respect of the FIR.
And a
Number
protest petition
says
is
so.
pending.
Huh?
A protest petition is pending.
By the which police?
Well, it's this is,
Okay.
Manoj will see Pandav Nagar Police Station, Delhi. Manoj will see on the second page, or we'll flip the page over.
police station is Pandav Nagar.
Pandav Nagar, Manoj. Manoj will see the first thing, says case type closure report. And then Manoj will see registration number 7 of 2024. That's the FIR number.
But that is on the challenge, man.
By the Pandav Nagar Police Station. That's all. And there's a protest.
And then a protest petition is pending. My submission is that considering the
Same is being
closure has been
challenged.
filed,
And the protest petition has been is being before the court of the Chief Metropolitan Magistrate. East Karkaduma. It is Karkaduma.
that's Karkaduma.
Karkaduma Court. Another thing you had said, what was that? I forgot.
Manoj,
The records they all produce.
So, the learned counsel also has submitted that as per the impugned judgment passed by the learned singleton, it is clear that the records, entire records had been produced and perused the then
What are the and the numbers that you.
on next para. The learned counsel for the appellate submits that 48% were to be screened. No, 40% had given their candidature.
no, Manoj.
48.
Manoj,
47 was screened.
47 was screen, Manoj.
But how many had given?
What happens is, Manoj, for the number of vacancies, they always create a zone of consideration which is 3 times.
Okay.
That is provided under policy at
48 then. The 48.
That's right. Manoj.
Submits that though the zone of consideration submits that 7% were screened and for 16 vacant posts. However, the mark secured by the appellant put him in the 19th position. He could not be promoted. Full stop. He also submits that the issue with regard to the respondent number 12 apparently having incurred losses for the company does not give a true picture as to how the business of insurance is being run. Full stop. In this respect, he submits that the loss incurred, he submits, for example, that when Mr. A makes a loss for the company at the rate of ₹10 per annum, and the next incumbent to the said post makes a loss of ₹5, then the same amounts to a vast improvement in the company finances. On the other hand, when Mr. A takes a profit for the company at the rate of ₹10 per annum, and the next incumbent makes a profit of only ₹5, then that amounts to a loss for the company. Next paragraph. Considering all the aspects, now considering the submissions by the council for the parties, we are of the view that the uh, council, the respondents should produce the mark secured by the candidates in the selection process conducted by the promotion committee. Accordingly, the same can be produced by way of a sealed cover also on the next day. List them on the prayer of the council for the respondents number 2 to 9. List the matter on
Friday, my lords.
Friday.
My lords, can it be serial number 1? Can it be top of the board, please? Because my lords, it will not take too long and then we'll be.
Then you can go off.
I can have a certainty about my flight.
You make a mention, will
My lord, the original documents.
they'll bring the original. You're not going to see it anyway.
Yes, my lord.
Well, it seems like.
Okay, that's right. The respondents council further submit that, wait. This- where is it? Where is that subjective satisfaction there, man? That in their affidavit they had said
8 months.
Not this one, I want that.
My lords, page 231, page of the writ appeal paper book.
231.
Yes, it's part of para 40, but it's continuing on page 231.
231.
Last but
Just right. The respondents council submits with regard to para 40 of the
affidavit in reply. Affidavit in opposition to the writ petition.
The affidavit in opposition
To the writ petition.
on behalf of the respondent number 3. To the
Writ petition.
Repetition.
petition. Comma, it has been recorded as follows. It is submitted that promotions at such higher levels are subjective in nature, comma, given the profile and accomplishments of the candidate coupled with the requirements of the company for the promotion pros, which are open to be filled. Page 231. Full stop. The respondents council submit that the explanation to the above para 40 would have to be read.
Specific query was posed by the court, my lords.
Well, that order
That's page 812 of the writ appeal paper book, my lords.
to be read in conjunction with
Page 812, order dated 18th March 2025, my lords.
the order dated 18/3/2025.
Para 41.
Passed in WPC 2697 of 2024.
Para 40.
No, of 2024. Where is?
Paragraph 42 man.
It had been directed. As follows, page 81. Next, that. Classified well.
May I read it out?
691. Huh?
May I read out the part of
Yes.
the order, my lords?
Where, which, where?
812, my lords.
812, I have this 691. Accordingly, in terms of the order dated 18/3/691, that additional was filed on behalf of the, on this point number 3. Wherein it has been stated with
690.
you will say there. In paragraph 4.
Para 4 to 6 minutes.
698 to page 700.
My lords, this 698 to 700 is my response, my lords.
That's what I'm saying. That's why we have said.
In the writ appeal, it is 461 page number. In the writ appeal paper book, they have also filed the entire record. I will say.
We are just giving your explanation to that because there's no point putting their question. And
That's right, that's right. And one last thing, my lords, regarding tweaking of the promotion policy, my lords, reducing the 2 years to 1.5 years, if my lords want to record that.
Okay, the learned counsel for the respondents for the submit.
Because that has been,
Speaking of the policy, the promotion policy, by lowering the the qualifying service of 2 years to 1 year.
1.5.
To 1.5 years and thereafter 2 years and subsequently to 1.34 years. And subsequently raising it to 1. What is it has not been put to challenge.
has A, not been put to challenge, and B, he has benefited from the same.
Put to challenge and he has, and the petitioner has also
Benefited from the same
benefited from the same.
in PE 23-24 during promotion exercise 23-24.
In the promotion exercise that had been held for filling up scale 7 vacancies in 23-24.
That's right.
As reflected in which, where was it reflected?
This is para 25 of his writ petition.
In 25 of the written petition. Then that list. Huh? We are doing this because we'll forget all this.
Please.
They will forget all this.
No, absolutely. That's one last chance to request for a time fix or a top of the board, my lords, if in case.
You mentioned on that day.
I'll mention. Highly grateful for a patient hearing.
Much obliged, man.
That's a thing, not then we.
Oh, no. Wait. The completion is. And then.
May I please, your lordship. That's why I'm praying for adjournment of the matter for today, lord. On behalf of the engaged counsel.
Okay, when do you want? When are you filing your affidavit?
By tomorrow,
By tomorrow.
Lordship may fix a date for next week if possible.
Okay, no problem. When do you want?
Any date as per the convenience of.
The council, what is your name?
Lordship, my name is not reflected.
You are appearing for whom?
S. Borgohain.
Adjournment prayer has been made on behalf of Mr. S. Borgohain, learned counsel for the appellant. Mr.
D. Bharadwaj,
D. Bharadwaj, learned
public prosecutor.
PP for the NIA submits that affidavit in a position will be filed tomorrow.
Tomorrow, or day after
Will
tomorrow.
be filed within 2 days.
Today.
This is the matter in the next.
Obliged to you.
Order dated 1st of November, lordship. The SP Uzai directed to. As per order dated 1st of November, lordship. The SP Uzai directed to submit the present status of the case.
Yes.
My lord, we filed affidavit and status report also.
Your daughter is how old?
Lordship, as per 17 years.
17 years.
17 years, lordship.
17.
17 years.
Are you sure?
Lordship. I have annexed the birth certificate, Lordship. I have annexed the birth certificate, Lordship.
Are you sure she's not in the neighborhood somewhere?
Birth certificate it says below.
Oh, kidnapped by Vikas Chauhan. Are you sure they have not eloped?
That is, Lordship, I have no knowledge, Lordship.
Anybody?
Because after the incident, Lordship, the boy has been following my daughter, Lordship, as well as she left the school, Lordship. Subsequently, on the date of Lordship, the respondent number 6, Lordship, kidnapped my daughter. And since that day, Lordship, the police did not recover my daughter, Lordship, and did not produce before any court, Lordship.
You have read the report. Just read the para 8, next page.
As per also, Lordship, information technology, technical analysis, Lordship. The victim and the accused are currently hiding outside the state of Assam, Lordship, in order to get police detection. Lordship, the police may be detect.
The police are not supermen. They don't know everything, and they cannot do everything. If they are hiding, where will they find? When you can't find, even they have got limitations. Don't think that they can do everything.
I am also trying to find out that my daughter, Lordship, but nothing could not, Lordship.
The thing is that it appears here, let our imaginations, wander a little bit. It appears that they have eloped. It appears that they have eloped. Correct?
Earlier, Lordship, because
earlier what?
Earlier, before the incident, Lordship, I came to know that the boy has been following my daughter, Lordship.
Oh, and what do you think? The girl did not allow him to
Lordship, we left the school, Lordship.
That's what now this is so. Now this is the result.
And now, Lordship, she is minor, Lordship, 17 years old.
What about the boy's family? Have you gone to the boy's house?
No, Lordship. The police, as per Lordship, the affidavit, Lordship, the police, Lordship, interacted the family members of the accused, Lordship. Their affidavit, Lordship, page number 24, Lordship. Page number 24.
Now what to do? Police will look for them. We can direct police to go and look for them and bring them. But when they can bring them, we do not know. They don't think that they can do everything in this one.
Lordship, my humble
Otherwise, all crimes would be solved everywhere.
before this honorable Lordship, the police may recover my daughter, Lordship, and produce the before the honorable court, Lordship.
That is why we have directed them. They cannot find now what to do.
Since 17 May, Lordship,
they are hiding from your.
I don't know. The family,
Probably they're hiding from the boy's family or not from you only.
also the family members are residing at Karbi Along district lordship, the police may interrogate.
They did, that for
Statement
taken.
para 4, read para 4. They've been arrested and they were released.
Earlier they filed the same affidavit lordship, same affidavit lordship.
Naturally, if the nothing has changed, what do you want them to write?
Okay, another item may be taken. lordship.
Supposing you eat omelette every day. There's no change in your diet. And someone asks you after about a month, what have you eaten? What will you say? Same thing. If there's no change. When there's no, what do you expect them to say? Anyway, I done the match. In the meantime, okay, right. Counsel for the parties are present. Mr. P. Sekia has submitted a letter dated 1911 issued by the Senior Superintendent of Police, Vijay, which is to the effect that the a petitioner's daughter and
Respondent number 6.
and Vikas Chauhan, son of Sri Baru Chauhan, are currently hiding outside the state of Assam in order to evade police detection. To subdue the father and uncle Chauhan had been examined by the Lanka police and their statements recorded, no evidence of their involvement had been found in the absence of, in the missing, on the issue of the petitioner's daughter missing, on the issue of the petitioner's daughter missing. Accordingly, they were released. And considering the above facts, this matter again after 8 weeks. Meantime, the police, if the police shall produce the daughter of the petitioner as and when she is located. The letter dated 1911-25 issued by the Senior Superintendent of Police Pajai is made a part of the record and marked as an exchange. What to do? Yes. Bless. Is the son of the. What do you mean?
Basically,
Oh,
the circumstantial evidence, maybe sense.
Oh, but it's a really
Confession, right?
and why should they get a land?
And there is another extrajudicial confession, only things are one thing here. That's the way. The man was, when he was like present. People that want to. He was the find it. But the police, the Caesar reports, the gown was, if the gown was recovered from the store. This is the only catch.
Did we make any notes earlier or no?
Lordship, I have made lordship. There are 12 witnesses, lordship. And there is circumstantial evidence and extrajudicial confession is there, lordship.
So,
That is
so,
only in front of father
so
and
the
mother.
killed whom? His sister?
No, wife,
One.
The appellant
Wife.
killed his wife.
one.
And extrajudicial confession made to?
Before father have suggested that you are the one who have killed your wife. And mother have told that he have met the son. My son have met.
Understood, there are as many as 13 witnesses, my lord, including the MO, medical officer and highway. Right. Only thing is, my lord, all the circumstantial evidence, man.
Okay, all are circumstantial. So basically, the main witnesses here would be the mother
Mother,
to whom he has confessed.
lordship.
That was in cross she denied.
In court, she denied.
My lord, in cross, it is not said in cross.
Let us see PW number.
3.
3. Page 13.
Number.
But specifically in her cross, she have stated that this is not the fact that the accused, page number 14. Page number 14 in
The
her
accused has been
cross.
sleeping in a cell. Not a fact. The accused has been sleeping in a cell.
I do not know whether the deceased Rina girl had committed suicide by cutting her neck. I have stated before the police that my husband had stated to me that someone had cut Rina girl. I had not stated before the police that I woke up from my sleeping on hearing the shouting of the accused Badal girl that he had killed.
Then the last line.
So he heard.
No, she has not. I had not stated before the police that I woke up from my sleeping on hearing the shouting of accused so and so that he had killed. It is not a fact.
It's basically what he's saying that he had not told the police.
Police.
He has not.
That's all. But in the in last line, she have again added, lordship. It is not a fact that the accused had not murdered his wife by cutting.
The only issue was that she heard him saying that she had killed his wife. Only thing was that he did not say this fact
To the police.
So what is the law with regard to this?
So the circumstantial evidence, the chain has to be completed. Man.
So it's like this. It's like this. I have told you that I have killed so and so, Mr. A. But the evidence you have said, I have told you that I have killed somebody. But you have not told the police that I had told you this. That's the thing. That's the only thing. Now, what is the law with regard to this?
With regard to the circumstantial evidence.
What is the law when a statement which has not been stated to the police is brought for the first time in the court?
If corroborated, that can be relied. But other witnesses.
Yes, madam.
PW5 is also there, lordship. PW5.
Page 17.
Page 17. From the down below, lordship.
I arose, second paragraph, I arose from sleeping and heard commotion in the house of the accused so and so. Then I went to the house of accused Badal so and found the parents of the accused, see so and so, as well as neighbors in the house of the parents of Badal God had stated to me that accused had committed murder of his wife so and so by cutting her neck. Then I entered into the house and
and found the wife Rina lying on the ground dead with cut injuries.
Persons caught hold of the accused and finally said, put in civil, we also found a dog and side going to the line. Now, it's.
Yes, so what remains?
My lord, only thing is, there are certain things, my lord. There are contradiction as regards the recovery of weapon. Weapon. Worship will find contradiction PW5 and PW12. PW5 just now your worship has gone. It is at page 18. Last part. Then the accused so-and-so stated that he somehow lost his temper and committed murder of his wife so-and-so. Then I, along with 2-3 other persons, caught hold of the accused and tied his hands in his behind and put him seated down. We also found a dove by his side. So according to him, the dove was recovered near him. And PW2, who is the 12, who is the IU, he says that
Okay, it was recovered from the storeroom.
recovered from the storeroom.
This was
And
after
that,
it was
and my lord,
picked up by the villagers.
after that dove was never
Frequency.
that dove was never produced before that point. And there was not even the forensic report whether that very dove was used. That is one aspect, my lord.
So you okay. So thou not
Not produced.
Was not produced. And there is no forensic report that it was that very dove was used for the crime.
what is the injury on the woman? Cut in the neck.
Not in the
So that can be done only by a sharp edge weapon.
of course.
Lordship.
But it is also a fact that the dove there were no blood stain was found. Page 33, your lordship will find no blood stains. Last part of page 33. Medical. There was no stain of blood in the dove at the time of Caesar.
90?
33.
33. Last paragraph, last 2 lines. There was no.
Yes.
At the time of Caesar by me.
What is your 313? What have you said?
There's contradiction in 313, Lordship. Question number 11 and 25. Question number 11 is on page number 39, Lordship.
Yeah, no.
PW4 Sri Kunu Gaur in his evidence stated that on the night of the occurrence at about 3 a.m., you came out from your house and aroused him from sleeping and stated to him that somebody had committed murder of your wife by cutting. Have you anything to say on this point? Yes, it is true.
Question number you reading?
11, 39. Yes, it is true. I had stated to my father that someone had committed murder of my wife, Rina Gaur, by cutting.
Someone.
But it contradicts in question number 25, Lordship. Question number 25, page number 41, PW12. IO Sri Nikhil Rajkhwa in his evidence stated that you stated to him that you had committed murder on your wife, Rina Gaur, by giving blow with a dove. Have you anything to say on this point? It is false. This is one, Lordship. And regarding injury also, question number 4 is there, Lordship. He denied about the injury. I do not know anything regarding the injury sustained by my wife. Once he has stated that to father that somebody have killed her with a dao, and in that portion, Lordship, it contradicts, Lordship. 24 and 25, Lordship.
Yes.
And,
Anything else?
and question number three, remember? Hirasai so in his evidence stated that then he came to your house and found your father and so stated to him that you had murdered your wife so in the house. Have you anything to say on this point? It is false. At the time of occurrence, I was not in house. I was in the park.
It contradicts only, Lordship.
Then, my lord,
So it's a double-storied house or a single-storied house?
no, test house, my lord.
Yes,
Test house.
so who was living in the house?
He and wife in one house in the same courtyard. Father and mother in other house.
Father and mother in other house.
And-
He, his wife, and two children. One is 14 years of age, other is 12.
12.
So
They were together.
what did they're not witnesses?
They were not
Maybe
even.
they were sleeping that time. What
No, their statements also have not been taken.
maybe they don't want to how does but you were there in the house.
I was there. I was there, but
If you were there in the house, then section 106.
Section 106 comes, my lord, but section 106, he could not say anything.
He could not say anything.
He could not say anything.
But was he
But-
there but he was caught by whom?
But no, he himself woke
He
up.
raised the alarm.
He raised the alarm.
Here is alarm.
Result came in the morning only. The incident is around 2 a.m.
So he shouted that he killed his wife.
Lordship.
Or he shouted that somebody killed his wife.
Somebody killed.
He shouted that somebody killed his wife. Which witness has said that?
Father said
Father and mother
said
initially.
he killed. Mother woke
No, that's what I'm asking. Mother and father have blamed their son.
son.
Has any witness said that it was somebody else other than the appellant who killed his wife? No.
PW5 also said that parents
So-
told.
My submission in this regard will be, my lord.
Yes, that's right. Then the mother. And then the father says here. No. Taking the plea available. Uh-huh. The valuable is gone. Listen, that. Like, no, what do they say? No man, no crime is perfect, as no man is. Because we live in his person. He was by the time a lot of little bit things. He told me. So he just came to better what has been. You know, so we have to really keep this. So he's a little more. Oops, out here also. W5. The parents of Shri Badal Gaur had stated to me that the accused committed murder. Yes, Yes.
My submission will, to that effect will be, my lord. When it is a circumstantial evidence, my lord, the chain has to be completed. Putting 106 of Evidence Act, my lord, is only added to that. When the chain is not complete, you cannot put it to 106. On the basis of 106, you cannot complete.
Correct, correct.
Man. Because why I say this, because, my lord, there are other witnesses in the same house. They were not even examined, not questioned, statements not recorded.
You mean to say the kids?
Kids. That is first
Kids,
submission.
elder one is 14 years old
14 years old.
and the younger one is
12 years. So, my lord, they are married for more than 15 years, my lord. There is no evidence whatsoever that they had a strained relationship or some quarrel or something. Nothing of that sort. Only at that particular night, my lord, it was the incident was occurred. So that motive is not present. Motive to kill. I'll rely on some judgment on it.
no motive to kill.
Nalagi isang motive. 2021 to 2021. It is 2021 Supreme within bracket SC 575. It says, my lord, I'll read slowly and then hand it over to your lordship. Section 101 and section 106, burden of proof. Burden is always on the prosecution to bring home the guilt of the accused beyond a reasonable doubt. Section 106 constitutes an exception to section 101. Section 106 of Evidence Act will apply to these cases where prosecution has succeeded in establishing the facts from which a reasonable inference can be drawn regarding the existence of certain other facts.
When the foundational facts are there, basically.
Which are within the spatial knowledge of the accused. When accused fails to offer proper explanation about the existence of such other facts, court can always draw appropriate inference. When a case is resting on the circumstantial evidence, if accused fail to offer reasonable explanation in discharge of his burden placed on him by virtue of the section 106 of Evidence Act, such a failure may provide an additional link to the chain of circumstances. The chain has to be completed, but if it can be proved, then the additional link to the.
When you don't give proper answers under 313 also, that can also amount to an additional link, can it?
Additional. And next, my lord, in a case governed by circumstantial evidence, if chain of circumstances which is required to be established by prosecution is not established, failure of the accused to discharge burden under section 106 of so is not relevant at all. When chain is not complete, falsity of defense is no ground to convict the accused. This is one. 24. Second is, my lord, 2024 Supreme SC 1164. I'm getting it. I'm getting it. 6, 7, 9, 11, 12, and 15. And also I'll read from the head note.
Yeah.
In conviction on the charge of murder may be based purely on circumstances evidences, provided that such evidences is deemed credible and trustworthy. In case of involving circumstantial evidence, it is crucial to ensure that fact leading to conclusion of guilt are fully established and that all the established facts point to irrefutably to accused person guilt. Proof or motive is not sine qua non in a case of murder. However, in a case based purely on the circumstantial evidence, motive, if properly established, assume great significance and would definitely provide an important corroborative link in the chain of the incriminating circumstances and strengthen case of the prosecution. Merely because of such quarrel were going on between the person, that by itself could not be ground of impute motive to accuse the appellant murder. So motive is also a relevant factor. Then about 106. Section 106. Circumstances purely last seen together. Section 1606 of Evidence Act shall apply. And the onus to explain itself to the accused only after prosecution succeeds in establishing basic fact from which the reasonable inference can be drawn regarding existence of certain other facts which are within the special knowledge of the accused. If prosecution fails to establish complete chain of circumstances in first place, then the accused failure to discharge burden under Section 106 become irrelevant. About the Section 106, the same observation in both these cases. And then keep it on. It will not take us. It will. Then, my lord, last week, 210(6) SCC, page 525. Major discrepancies in prosecution evidence. Conviction reversed, conviction by trial court, appeal by the High Court. Murder weapon never produced before the court and necessary witnesses not examined. What's it been written? This. Murder weapon never produced before the court and necessary witnesses not examined. High Court held wrongly accepted the evidence or recovery of the so-called murder weapon. As I said, discovery could not be relied upon in absence of weapon being produced before the court. Prosecution also did not give any explanation whatever about disappearance of murder weapon. Moreover, there was hardly any evidence of discovery. Again, Dr. So-and-so, so-and-so. This is regarding not producing the murder weapon and not examining the relevant witnesses. And it also said about motive. Circumstantial evidence, motive, relevance. Well, motive is an important circumstances in case wherein prosecution is based on the circumstances. Motive is also important.
There is evidence here that you're alcoholic and you were drunk that time.
No, it was not there whether that night I was drunk or not, but normally.
Normally you're drunk.
Normally, that's what I found. Not that particular night. Only one witness probably said. No, doctor.
Anything else? That's all? Yes. I think you're relying on the evidence of PW 1, 2, 3, 5, 4 also. Everyone, even the mother is against you, your father is against you. Your children are not saying anything, they're keeping quiet.
They were not even, their statements were not recorded.
No, they're not saying anything. You see, PW1 says, I found his son and daughter, but they did not say anything regarding the murder of my sister. Anything.
There was not even promotion. Because they
Actually,
were sleeping
because
together.
according to them, you killed her while she was sleeping. The problem is, now you see the issue is this. Circumstantial evidence might say there is none, but what about, okay, supposing we agree to your submission. What about extrajudicial confession?
That was probably under duress because the villagers.
To your mother?
No, not mother.
What duress?
The villagers say.
No, this is before other villagers came to the scene. You had
parents.
the and your father and mother have been telling it to everyone.
They have informed.
They have informed everyone else.
Lordship, I'll rely on the state judgment of Lordship 2012 6 SCC 403 Shahadevan
2012
6 SCC
6 SCC
403
para
para 16 Lordship extrajudicial confession.
Only thing is there is a slight discrepancy with regard to the recovery of the weapon.
Recovery of the weapons.
That's all.
And that was not produced.
That was not produced, but at the end of the day, the injury caused is not by hand. It is with some weapon.
Weapon and it's corroborated.
And it has been seen. Only thing is, due to the slipshod manner in which the prosecution has done their work, doesn't mean that we should throw the entire case. When the fact that you had confessed the crime has been reported by you to your mother and your father, unless you are saying that your father and mother are all liars.
I don't say that. At that moment, the state of mind, maybe I do not know what was the state of mind.
And it happened what time? It happened at night while they were sleeping. 2 a.m. So, according to your mother and father and everyone else who caught you there, you were in the house. Now you come to your 313 statement.
He have denied that he was.
Denied that you were in the house.
That is
Now, how do you reconcile the two? Question number 3. At the time of occurrence, I was not in the house. I was in the pump.
alibi that has to be proved by him.
Clear alibi has to be proved. Right. Third, Mr. Vijay Talukdar, another senior counsel and MX Cure for the appellant, assisted by Mr. P.K. Medi. Also heard Ms. Abraham, learned additional PP. Hearing concluded, judgment reserved. Okay, no more time. No.
Ma'am. Okay, before going to start my
Oh, this again.
May it please, my lord, I am appearing in the criminal.
Always he comes last. What's the deal? And we don't want to release you also. You are the main culprit.
No, my lord,
Evidence is against you.
at the time of hearing, your lordship will find who is the main culprit, my lord. No, I am, right now, do not raise such type of question, my lord. But allegation is there, but allegation have not been proved. So far, I have gone through the evidence on record. So, my lord, our simple prayer right now, my lord. Yes, ma'am. For some days, at least some
I
days.
file my objection against his IA.
So what is that?
Lordship,
Can he be granted?
because Lordship, he prays for parity, my lord, but as regards the other accused person, some are accused, Lordship was released on the ground of juvenility, some on for old age. But I don't find Lordship, the present accused appellant.
What about the case against him? Is evidence is good.
Yes, Lordship, PW4.
Ah.
He witnessed accused Nirmal Paul along with other accused persons armed with spears and lathis, assaulted Shri Subodh Paul. 2 persons' lives have been taken by them. As a result of which they received grievous injury.
Oh, my lord.
Only the lawyer looks innocent.
That's my lord.
Your client behind you is the badmash. Appears to be.
My lord, what happened? PW4 has already been declared hostile.
Then PW7
PW7
specifically deposed all the accused persons present on the dog assaulted Anukul with lathi and spears. Nirmal Paul had a lathi and a 3 kg weight on his hands during the time of occurrence. 2 persons, two brothers have been killed, my lord.
No, the difference in separate moment, my lord, incident may be happen, but these persons, so far I have gone through the evidence on record. In the final hearing, my lord, he may be acquitted. If your lordship is pleased to run through the evidence on record. There are allegations, but that has not been proved, my lord. PW1 Ajay Pal, my lord, what my
4 and 7 questions.
You look very innocent.
He is my lord, a member of the bar, we know him.
Innocent. When we juxtapose that appellant,
Oh, one of them.
yes, instead of you, then
my lord, what happened?
release you on bail.
If
You'll disappear.
all other no, not for disappear, my lord. With certain condition, my lord. With certain conditions, he may be released on bail. As the all other accused persons released on bail, my lord. In the meantime, he has completed 10 years in jail, continuous.
Yes, I don't know what to do. So what is that means we cannot you see have to see the
At the
facts
face
of the
of,
case.
my lord, at the face of it, prosecution has got a good case. But he cannot claim the.
Give a good ground.
Yes, good grounds, my
Maybe.
lord. IFI could. Either he's suffering from any illness or something like that, then
Versions of the PW7, your lordship will find 2 versions. In the SIP, examination in SIP, 1 version, and in cross examination, what were total different versions now.
You're very unlucky. Your case always comes at the end. Because now because I'm having this DB1 also. Otherwise, we could have probably done it earlier. Please share with.
Let, with certain conditions, my lord. At least.
And
for
is a
some
prisoner
days,
to 34 case, my lord.
till hearing of the
Not
petition, my lord.
149.
Till, my lord. He may be, that aspect. may
You
be
will, you will,
considered, my lord.
we will not see your face anymore once you go out.
Above 10 years, he is in jail continuously, my lord. Now his wife and minor children are suffering from severe. Yeah, 61, 43.
Yeah, 61 years old.
Now he may be 60. At the time of occurrence, 43, my lord. Now it is 2025.
How long have you been in jail?
10 years, my lord. Above 10 years.
Only.
He is in jail. All other accused,
Should
all
we fix
other.
another date? No.
No, she may, maybe please to. Maybe in the coming week or call special DB.
Not coming. Not coming. Last week.
And then in the meantime, bail may be granted for
All purpose who are benefited by your lordship's
some
order.
days, my lord.
They
At
are
least,
safe.
at least 1 week. At least.
They all have their, that's why they
Yeah,
all
they have
support
got
it.
the
Because
benefits.
we have been informed that his wife is suffering from illness, my lord.
In fact, my lord, I am put, I think, let me know 94. But in this case, most of them have released on criminal pleas. And the Shibu part is my client. He is the main culprit who was given a deadly blow, and consequently he died.
That is a reality.
And they all are brothers, my lord. And one thing has not come out in the light. Why suddenly there was a quarrel? What is the root?
Anyway, so now you all are happy. Now you all are blaming Shibu Paul who's dead.
Yes, they are all whole families out there. My lord, he is also my brother, my lord. That's why, my lord, we are praying there for 10, 15 days till the next final hearing in the on behalf of the bank committee.
We'll list it again. List the matter on
Till then, my bail.
17.
Till then, my bail.
No, 17 might get lucky. We don't know.
Till then, my lord.
Till then, my lord.
There is at least.
Was 10, 15
Considering the all
days.
aspect of all the.
Because of you, they are all coming. If you are released on bail, they will not come again.
We assure you, my lord, we know, my lord, what is the consequence of this case. We know. That's why.
My lord, all other accused persons, accused appellant have been released on bail except this person, lord.
On the ground, juvenility and old age, my lord, nothing
Juvenile
else.
is different thing.
Juvenile, there's nothing certain about that. Also.
So, on any condition, till hearing of the matter, my lord, he will be released.
17, another 15 days.
For another 15, let him out, my lord.
My lord, for 15 days. No, my lord, for 1 week may be given for the sake of his wife's treatment, my lord. So I have been informed orally, but no certificate has been given. That is why I did not annex. Orally informed that his wife is suffering from illness, my lord.
Illness?
Yes, my lord. Orally informed me.
So but we work with documents, we don't work orally. That's the
my lord, also children and considering his long detention, continuous detention, at least for
okay, orally told you what problem she has got?
She has got children, my lord.
Oh no.
And suffering from viral fever. Suffering
Orally, what illness has been got?
Viral disease. Viral disease, my lord. Yes. My lord. Thyroid problem. Disease বুলি কৈছে ব্যাপার. So
you said viral disease.
No, it seems she's having thyroid problem.
That's husband is out, my lord.
Ten
You
years
can
is out.
imagine the condition of the one.
That is why, my lord. Continuously 10 years, my lord. Without any leave, my lord.
My brother is saying your wife might be happy.
No. Why want entirely for husband?
Otherwise, you will beat her up and you might do this and that to her.
On any condition, my lord. Then till hearing of the
17 will decide. Either to set you free or put you permanently in jail or maybe allow you bail.
At least for 1 week may kindly be considered. At least 1 week till then.
See, Mr. Counsel, we cannot, we cannot act on oral submissions made by your wife to you. It has to be in writing.
Orally inform me, my lord, about phone. That is true, my lord, that she is suffering from some disease.
When did she inform you orally? When did she inform you orally?
Yeah, I am suffering from some disease, my lord.
कितने जनाइसे हुडी से बोल कितने जनाइसे बीमार हुआ बता
At the eyes of preparing petition, my lord.
At time preparing petition. When was this?
What
कितने
you did not
फाइल कर सर आए तुम कितने फाइल कर सर
I feel me
Which month?
Yes.
Anyway,
तभी
okay, we'll see. Yes. What is your case?
My lord, yeah, the order was passed following the other order of the repression, my lord.
Much I know.
Yes, my lord. So,
The order passed.
yes, my lord. Order passed, my lord, is,
No, what is the difference now in this case?
yes,
You are saying that only 61 writ petitioners were holding the post of superintendent, BR. The other writ petitioners, that means 148 writ petitioners, they were holding what post?
my lord, there is, my lord, my lord, those who are, my lord, 1/1/1996, my lord, before that, my lord. They will get the benefit and we have already released them, the financial benefit to them, my lord. Total, my lord, in this present repression, my lord, there is 148 repression, my lord.
Okay.
So this order was passed, my lord, initially the one Chandra Kumar, my lord, this repression, my lord. The WPC number 1537/2015, my lord, Annexer C, my lord. Annexer C. So this in a one petition, my lord, is in this following this order, my lord, this your lordship passed the present the order which this in the review petition, my lord. So in that case, my lord, he was in that particular grade, superintendent grade 2, my lord, before 1/96, my lord. So fifth pay commission and sixth commission, what recommendation was there, my lord? In our stand was in the state representation, my lord, as per the pay commission, my lord, he will get the notional benefit, my lord. So therefore, this honorable court, my lord, on the one Madras High Court also there is the order, my lord, and there is no jurisdiction. So it was transferred to here, my lord. The main representation 1537/2015. Then they directly they also get the area, my lord.
Correct. So,
Clear. So in our the present case, my lord, this only 61%, my lord. Those who have already given benefit, my lord, they were, my lord, the superintendent BR2 EM before 1/196. And there is some I've given it a list.
no,
my lord.
Mr. Counsel, look. What about the 148 remaining writ petitioners? What about them?
My lord, this total, this in representation is 148 writ petitioner, my lord.
148 writ petitions.
Yes, my lord.
So 61 out of the 148
Yes, my lord.
are eligible.
Yes,
Then what about the remaining?
remaining, my lord, they are after this 1/96, they are promoted to this state post, my lord. Superintendent 2, my lord.
Okay,
This is my next F2.
they are promoted to superintendent grade 2 after 1/196.
Yes, my lord. What the judgment,
Question of areas for them.
Yes,
So don't give them areas, that's all. If they're not eligible for areas.
yes, they are not eligible.
Then you don't have to give them areas.
No, we have not given. This is our.
Then what is wrong?
So the direction was made to pay as per this following judgment, to pay.
They are not challenging. They have not.
Yes, ma'am, not challenge.
Then
Yes.
what is wrong?
So this is
Mr. Saikia.
My lord, technically, my lord, this review petition is not material.
Why?
Lordship, kindly turn to page 70. The review petition, my lord.
Why? Because they had agreed.
No, my lord, there are 6 respondents in the original writ petition, my lord. 6 respondents. And my lord, the present review petition has been filed by 3 respondents. Out of the 6 respondents, my lord, only 3 has filed. So,
And
my lord,
the other 3 have not been made parties.
they have not been made party and they are not before the lordship. So, my lord, on that point, my lord, non-joinder of party, I have relied on two decisions of this honorable court, my lord, wherein this honorable court held that if the official respondents are conjointly do not approach the court, my lord, for review, then the review petition is not maintainable. That is one aspect. Other aspect, my lord, even in respect of the overseers also, my lord, this honorable court has already granted the benefit of fifth CPC, that is 5,000 to 8,000.
Overseers, you mean to say those other persons are
Yes,
overseers?
yes, my lord. Yes, my lord.
Overseers, so they are already covered by the fifth and sixth CPC.
Yes, my lord. This honorable court in the case of Ghanshyam Vishwakarma,
That they already covered, correct?
no, my lord, they are also entitled to the back wages also.
Huh?
They are also
No,
entitled to the.
they are already covered by that, I think,
Superintendent grade 2 is the promotional post to the from the federal cadre of overseer, man.
correct. No, then it became merged. Then they had to merge the two.
Yes, my lord.
It was amalgamated.
My lord.
And the question of payment of arrears was made in relation to the overseers only. It was made in relation to the overseers only. You come to page 161. 160.
Yes, my lord. Yes, my lord.
You see, Border Roads Organization, Overseer Civil, higher pay scale has been demanded for the post of overseer in Border Roads Organization on the ground that the minimum qualification for the post is diploma in engineering.
Yes.
The post carries minimum direct sensor. These minimum qualifications have been prescribed in 1996, fifth CPC in the report, had recommended the scale of pay of all posts carrying minimum direct recruitment qualification of diploma. So overseers also were diploma holders in engineering.
Well, what they are saying in the review petition that the overseers they are not entitled.
No, they are already entitled by this.
Persons holding the post of superintendent grade 2 only they are entitled. That is their contention, man. That is why, my lord, in the facts also, my lord, there is no merit in the review petition.
Yes, Mr. Counsel.
Well, my instruction is, my lord, if this, my lord, is.
But you're not explaining how, where is the review required?
My review requirement, my ground is, my lord, this, my review is my ground, my lord. My lord, the page 41 starts, my lord.
Okay, let us see the judgment first. Let us. Which para are you reading?
My lord, in the case of the review petition number 60 of 2018, my lord.
Yes.
Paragraph 30, my lord.
30.
30, my lord, 30.
Yes.
This review petition also fails on the ground of non-joinder of necessary parties. The 5 respondents in the proceeding of WPC number so-and-so were so-and-so. This instant review petition has been filed by 2 out of the 5 respondents in WPC number so-and-so. The state of Assam through the Commissioner Secretary to the Government of Assam Education Department and the Director of Elementary Education Assam. However, the other 3 respondents, namely the Commissioner of Government of Assam Finance Department and the Deputy Inspector of Schools Karimganj and the Treasury Officer Karimganj were neither arrayed as a review petitioner nor they are arrayed as former respondents. The said 3 parties were proper and necessary parties in the review petition. Without those presence, whose presence the judgment and order dated so-and-so person cannot be reviewed.
What about the other?
The other judgment is, my lord, review petition number 85 of 2018, my lord. Paragraph 22, my lord.
Okay, then next.
Next, my lord, the Ghanshyam Vishwakarma, paragraph 1. 9 and 22, my lord. Paragraph 1. By this writ petition, the petitioner, who is a regular overseer, is praying for a direction to the respondents to revise his pay scale at the rate of 5,000 to 8,000 with effect from 1/1/96, which is the revised.
No, this is with regard to the merits.
Yes,
No, I don't know. I want on that for,
non-joiner of party.
yes.
That is,
Any other?
that paragraph 22 of, my lord, review petition number 85 of 18, my lord.
Only that, only Justice Surana's judgment.
Yes, my lord. Both are Justice Surana's judgment. Review petition.
Yes.
Well, in this thing, I'm not ready, my lord. Yes, so, my lord, I mean, allowed time, my lord. So that one, but I.
Right. Mr. Committee, the learned PGC, prays for time to go through the order dated 1/12/21 past in. No, past in review petition 85 of 2018. The state of Assam versus Srimati Manita Devi. Combined as much as all the parties in the writ petition have not been made parties in the review. On the prayer of the petition, on the prayer of Mr. S.K. Medi, list the matter when?
Well, immediately after.
Tomorrow.
My lord, they have, my lord. On 8, no.
8 might be difficult.
Then my lord, 12.
No. What about the after tomorrow? It's just read this.
Of fifth of this.
You read, huh? On 5th.
Fifth.
Lordship, in terms of honorable court's order, we tried to deposit the check, my lord, yesterday, but registry is not receiving it, my lord, because it's not in form, it's a PLF check, my lord.
No.
Public ledger account check, my lord.
What do you mean? What is a public lecture?
Lordship, you have to put. It's a government ledger account, your lordship.
No, this is nothing. You are not saying anything.
They have rejected it, your lordship. They're not accepting it. Actually, from this head, it is to be submitted to the director. Then, no, lordship, since your lordship has directed us to submit it before the registry, we have straightway have brought in the check and submitted before the registry. But registry is not accepting it. There is a note, my lord. Because director, after verification, he'll call the person concerned and fill up the form, fill up the check, and accordingly, the money will be submitted to the treasury and it will be disbursed in his account.
Yes, you are kidding. Are you agreeable? Yeah, if you're not agreeable, where is?
No, lordship. What happened, lordship? This is not this is a concerted order, lordship. And lordship, there was twofold of lordship order in the order passed by lordship.
No, you see, it's a simple question.
Lordship.
They are saying, supposing we deposit 10 lakhs and then we pay you the rest as per Tarsem Singh or whatever, not Tamsher Ali. Are you agreeable? If you don't agreeable,
No,
then
lordship, I'm not agreeable.
not agreeable. But then you're not agreeable.
The check would be returned back.
I would.
And lordship, I'd like to submit, the BTC authorities have taken up a resolution, it will be coming out within 2-3 days, my lord. That entire amount to the contempt petitions have been filed before the honorable court. Whatever is due, they would be paid, your lordship. Resolution have been taken in the BTC secretariat.
Then it's better for the contempt petition to carry on.
And it will take some time, your lordship.
Maybe. Because this way to, until how much, what is the serial number of the contractor who has been paid?
Your lordship, what they have done here 115, as I have submitted it earlier, and till what serial number it is paid, because I have taken instruction from the authorities concerned, as has been paid to my learned friend 5 lakhs earlier. So in order to meet the, as part of fund, my lord, the payment has been disbursed to the, like, not the whole amount, but in order to satisfy all, some to 5 lakhs, some to several lakhs, like that they are trying to satisfy all the contractors, my lord. Because at the same time, money, entire money.
Following term share, you're not.
Carefully, we have taken a resolution, my lord.
Okay, right.
Lordship, you're dismissing it. Then this may be observed, my lord, whatever the developments.
Yes.
Yes.
Ms. V. Buyan. This takes on this order dated 16/11/20. One, two, three. Four.
5 lakhs already
Five.
to be 15 lakhs. Only my less amount would be due, my lord.
Six. No, that I'm not on that. This is only review. Six, five, six, huh? 4, 5, 6. Seven or next. On a query made to the review petitioner's counsel as to which serial number, no, as to the contractor as to the serial number of the contractor to whom contractual dues have been paid as per the liabilities list prepared by the BTC. The learned counsel for the review petitioner submits that the petitioner is at serial number, the respondent is at serial number 115 of the said list. To start. Next paragraph. This court was of the view that if was of the tentative view that if the appellant, if the review petition could deposit rupees 10 lakhs in the registry of this court, the issue raised by the review petitioner may be considered by this. Accordingly, Ms. B. Buyan, learned counsel for the review petitioner, had taken steps for depositing 10 lakhs in the registry of this. However, the said proposal of the present proposal mooted by this court has not been accepted by the review petitioner, by the respondent, in as much as the same would amount to, no, same would amount to, in as much as the respondent wants the entire amount in terms of the order dated 10/4/2020, passed in WP 888/2020. Next paragraph. On considering the grounds for review made by the review petition, this court finds that no grounds for review has been made out. By the review petition. Especially when rupees 5 lakhs has already been given to the writ petition on 13/3/2020. Entry of the reasons state above.
Lordship, one more observation.
The review petition stands dismissed.
Lordship, we have come up after, that may be observed after,
Come up.
and belatedly we have.
It's there, that it is there. 2.5 years, it is there.
Original check may be returned to us then.
Yeah, you can take it back.
Yes.
It's not given to anyone. Please take it back. Get back.